Yes.
I beg your lordship permission, my lord, to move a writ petition unlisted, my lord, today.
What is the subject?
Eviction matter. Well, one complaint has been filed, my lord. It was uploaded in the social media, my lord. On that basis, my lord, the eviction is sought to be done,
Okay, if time permits.
my lord.
May I please, I beg to mention item number 14. I may be allowed to withdraw this petition, my lord. 14.
14.
Yes, my lord.
Okay, Mr.
M. Shalim.
M. Shalim, learned counsel for the petitioner, has submitted that he has received instruction from the petitioner not to press this writ petition. So it is, and is the finance department in view of the above submission made by Mr. Shalim, learned counsel for the petitioner, writ petition is dismissed as not pressed.
My lord, it's a prayer to move a matter for today, my lord. The urgency is that JMD has issued a sealing order to the petitioner's school, my lord. So the exam is also scheduled today, my lord. So the urgency is that, my lord.
Okay.
Much obliged. And one more, my lord, a closure notice has been issued to a eye clinic by the health department. That may be tomorrow, my lord.
Not tomorrow, Wednesday.
My lord, closure notice has been issued, my lord.
Wednesday.
Much obliged.
Mr. Lordship, I beg to mention for the listing of one WPC, 5724.
Pending matter. Pending.
It's unlisted, Lordship.
What is unlisted? What is the subject matter?
WPC 57.
Subject matter, madam.
Writ petition civil.
Who is your senior?
Jibara.
You don't know the subject matter.
Lordship, I'm instructed to.
You cannot get the unlisted permission without knowing this subject matter of the petition to be moved. Next.
May I please, the lordship? Lordship, I beg to mention item 16 on the daily list. Similar matter with the identical facts are listed up for hearing on the 17th. May I humbly pray for the matters to be taken up together on 17th?
Let us examine first.
Your lordship, may I pray for an unlisted matter today? What has happened is that my land has been requisitioned against requisition.
Requisition.
Thereafter, I preferred an appeal. Appeal is pending. Without disposal of that appeal, they are now proposing to take over possession. My only prayer will be that pending the appeal, the possession should not be carried out.
Okay, right.
Please, Your Lordship, I beg to mention for the listing for the matter for orders. The similar matter already been disposed of and involving the same issue.
Give it to the court master.
Well, I beg to mention item 49, madam. Need some accommodation. We need to file reply, madam. We are for State Bank of India.
You are for the State Bank of India.
I've taken consent of the others.
It's not 49. To see. Why it has come for orders?
There's some bank freezing.
Huh?
Bank freezing.
No, orders column. You are for bank.
State Bank. We have been recently engaged, my lord. Need to take instructions.
Sir. Okay.
The
The counsel for the petitioner has submitted that he has received instruction to appear on behalf of the respondent number 2. And he file Ukaladama.
No, we'll file, madam.
Okay. And he'll file the Ukaladama within a short time. Within a week's time. He has ordered short. How much time you need?
2
weeks
weeks
time.
2 weeks.
2 weeks time to file the to obtain the necessary instruction and to file the counter affidavit on behalf of the respondent number 2. The request made by so and so is accepted. Place the case on so and so in the appropriate column. As accepted as it is stated to be made with the consent of the learning counsel for the petition.
2nd September 0209.
In the appropriate column.
Grateful.
May I be the lordship? Lordship, I beg to mention item 10, lordship. It may adjourn for the day, lordship.
Item number
10,
10.
lordship.
On the request of Mr.
Saiful Islam, yes, Islam.
S. Islam, learning counsel for the petitioner. The case is passed over for the day.
Much obliged, Lordship.
May it please your Lordship. Lordship, with the consent of the other side, I beg to mention item number 40 of the daily list, Lordship. Lordship, we were directed to provide, bring instructions, Lordship. Instructions awaited, Lordship. Lordship, 1 week time may be given, Lordship.
Yes, who is for the petitioner?
Lordship, A.R. Bhuya, Lordship, I have
Okay.
taken consent of
You have informed.
Lordship, I have informed, Lordship.
Yes, P. Burua.
R.
R.
Bhuya,
Burua, learned counsel appearing for the
second
respondent.
education department.
Secondary Education
Yes.
Department has sought for listing of the case after a week in order to complete, in order to obtain further instructions. It is submitted that consent has been taken from the Learned Counsel for the petitioner to make the request to stop. In view of the above, let the case be listed on so and so.
24th August, 2408.
May it please your lordship. I beg to mention for listing of a writ petition, your lordship, on 19th of August. Before granting the listing, your lordship, this matter will be listed before any other bench without your lordship. Since this is a senior bench, I'm making a mention here, your lordship. Deeply obliged.
May it please, my lord. My lord, with the consent of the other side, I beg to mention item number 42 and 43 of the daily list, my lord. Within this week, we are going to file our affidavit in opposition, my lord.
42, 43
43.
used with 41 also.
My lord, 41, honestly speaking, I couldn't contact with the petitioner, my lord. Our instructions are awaited in this matter, my lord.
Mr. H. Burua, Learned Counsel on behalf of Mr. B. Goel, and Standing Counsel, Finance and Taxation Department of Assam, for the state respondents, has sought for and is granted 2 weeks' time to file the counter affidavit. Counter affidavits on behalf of the state respondents. Post of it is submitted that consent has been taken from the Learned Counsel for the petitioners to make the prayer. Raise the cases on friends. You inform SK Agarwal.
Lordship,
My lord.
2nd September, 0209.
I'm for 42. Interim may be continued, Lordship.
The interim orders whoever passed earlier shall continue till the next set of listing. Okay, your Miss
B. Sarma, Lordship.
B. Sharma, Learned Counsel for the petitioner in 42, and Mr. S.K. Saha, Learned Counsel for the petitioner in 43 are present. For videos.
May it please your lordship, I beg to mention listing of a writ petition for 17th of August. Yes, 17th of August.
No,
Okay.
and pending matter,
Yes, lordship. Last listed on 8/6.
give it to the court master.
Okay, lordship.
May I please, your lordship, with respect to item number 35, we have not filed our affidavit in opposition in this matter as the officer concerned is hospital errors. Lordship, on last occasion, I've informed the council, but he told me that you better take it on when the matter reaches. So lordship, just the intimation, we have not filed our affidavit.
Okay, let us wait then.
35.
Lordship, my senior counsel told he want to join through video conferencing in this matter, item number 35.
Lordship.
Let the matter reach.
Lordships.
Please allow Lordship.
Much of.
I beg to mention item number 31 on behalf of Surudip Day, my lord. There's some difficult.
Yes.
Let it be on Friday, Lordship. So,
On the request of Mr. B.
Digo.
D. Learned Counsel appearing for the petitioner. Raise the case on so and so. Mr. H. Burua, Learned Counsel on behalf of Mr. B. Gogoi, Learned Standing Counsel, Finance and Taxation Department, who is in attendance, has no objection to the prayer so made.
Friday, Lordship.
14th August.
Good now. My lord, a similar pair, my lord, item number 33, my lord. 33, my lord. I am here today, must have 33.
30, same.
Deeply obliged.
1408. Daily list for withdrawal. Item number 1.
Please, your lordship. There is a technical difficulty, my lord. As well, the petitioner is the director of a company and who had applied for NOC for the purchase.
You want to withdraw?
Yes, my lord. So liberty may kindly be granted.
Miss
P. Goswami, my lord.
Learned Counsel for the petitioner has submitted instruction, the petition wants to withdraw the petition with the liberty to file FS. Mr. A. Aforesaid, Learned Standing Counsel, Revenue Department for the respondent number 1, and Ms. M. Borman, Learned Junior Government Advocate for the respondent number 2 and 3, who are present, some have submitted that they have no objection to the prayer made on behalf of the petition in view of the above submission made by Ms. Goswami, Learned Counsel for the petition. The petition is dismissed on withdrawal, with the liberty, comma, as sought for.
Reply.
For motion, item number 2.
My lord, violation of honorable court's order, my lord, that is at page 39, my lord, next at 12, my lord. My lord, they have carried out demolition, my lord, in spite of this order, my lord.
Counsel for the petitioner. This contempt petition is preferred, alleging non-compliance of and non-compliance and disobedience of an interim order dated 27/7/2026, passed in a writ petition WPC number 3889/2026, wherein the present petitioner is the writ petitioner. Full stop. Para, it is brought to the notice of this court that in the on 27/7/2026, the following interim order was passed. Paragraph 11 to page 43. Para, it is averred that the copy of the order dated 27/7/2026 was duly brought to the notice of the respondent on 28/7/2026. But the respondent had carried out demolition drive in the subject plot with JCB.
Yes, my lord, JCB.
On
31, my lord, 31/7.
31/7/2026. Issue notice returnable on such step by raise speed post. Within 2 working days from today.
All right.
14 September 1409. Item 3.
Is a contempt petition alleging violation of the order dated 22/7, page 15, Lord. Operative part, page 18. We fight for the application of the demolition orders.
Heard Mr. BP Bora, learned counsel for the petitioners. So this contempt petition is filed, alleging non-compliance and disobedience of an interim order dated 22/7/2026, passed in a writ petition WPC number 3791/2026, which is preferred by these petitioners as writ petitioners. Full stop. Para, on 22/7/2026, the following interim order was passed. Para 9.
Yes.
Page 18.
Yes.
It is averred that a copy of the order dated 22/07/2026 was duly brought to the notice of the respondent on 23/7/2026. But the respondents did not ensure for stoppage of further construction activities. And as a result, unauthorized constructions are going on till date.
Till date, Lordship.
Issue
We have-
notice.
We have also annexed the photos, Lordship.
Issue notice.
Lordship, one
Refundable.
thing I wanted to point out, respondent number, CEO is a party, but he told us that the town planner was entrusted with the job of doing this. This is respondent number 2, but the town planner was not a party to the original.
Then we have to issue respond number 1.
1.
Issue notice to the respond number 1. Notice is made returnable on so and so. Petitioner shall take steps by speak post to need to work in this form today.
Otherwise, there are judgments, Lordship, wherein anybody who is brought, or the order is brought to the notice. Even
That has to be brought on pleading. Thereafter, we can carry over. That judgment, it is not that first, he has to say that I have entrusted the task.
Deeply obliged. Deeply, I understand.
Otherwise, then that is not the procedure.
Yes, deeply obliged.
Yes, it can spill over to other respondents,
Yes.
but there has to be specific admission by this respondent
Deeply obliged.
or from the materials on record.
Deeply obliged. I understand.
1409, 14 September. Item 4.
Application online for the notification of by order.
এখন দিব না।
In the rejection order.
হইছে ওয়াজেন পাও তোমার না মানে ডিরেকশন দিছে সরকার টিচার লাস্ট প্যারাগ্রাফ লর্ডস লাস্ট প্যারাগ্রাফ লিসন ভিতরে গুলো আমার লেটার
So, direction is made by the appellate authority
Yes, Lordship, to
to
complete the action.
reprocess the
Yes.
petition application
Yes,
based on the registered sale deed,
yes, Lord.
right?
Yes,
So let him do it.
yes, Lord. That will suffice our purpose, Lord.
Heart, Mr.
M. Ahmed.
A.M. Ahmed, learned counsel for the petitioner. And Bodoloi, aforesaid, learned standing counsel, Revenue Department, Government of Assam for the respond number 1 and 2. And Mr. H. Sharma,
345.
additional senior government advocate, Assam for the respond number 3, 4, and 5. Full stop.
As it does, no?
Para 2. Para. On 29/7/2026, Commonwealth State Council was asked to obtain instruction as regards the present status of the appeal stated to have been filed by the petition on 5/12/2025. First up, para. Today, Mr. Sharma, learned additional senior government advocate appearing for the respond number 3, 4, and 5, has submitted that the first appellate authority considered the appeal preferred by the petitioner under section 8 within bracket 1 of the Assam Right to Public Services Act 2012 against the rejection order dated 24/10/2025 passed by the designated public servant, that is the circle officer, Kolkata Revenue Circle, District Borpeta, within bracket the respond number 5. Post of upon consideration of the appeal, the first appellant authority has directed the respond number 5 to reprocess the mutation application. The application submitted by the petitioner for delivery of the notified public service, quote, mutation after deed registration, unquote, on the basis of the registered sale deed, and to complete the exercise within the stipulated time designated for mutation by deed inheritance. And to submit a compliance report in that connection. Full stop. Para. Learned counsel appearing for the parties are in broad consensus that since the first appellate authority has directed the designated public servant to reprocess the application of the petitioner for the aforementioned notified public service within the stipulated time period prescribed for the notified public service, comma, the repetition can be disposed of with a direction to the designated public service, public servant, that is the respondent number 5, to dispose of the application, to reprocess and dispose of the application of the petitioner as expeditiously as possible. Post of having regard to the instruction placed by Mr. Sharma as regards the direction made of the, on 5/8/2025, first appellate authority. Instruction placed having regard to the instruction placed by the learned additional senior government advocate that on 5/8/2026, the first appellate authority has directed the designated public servant to reprocess the application submitted by the petition on 24/10/2025 for the notified public service on the basis of the registered sale deed, and to complete the exercise within a prescribed time period, comma, distribution is disposed of with a direction to the designated public service servant, that is the respondent number 5, to reprocess the application of the petitioner for delivery of the notified public service mutation after deed registration within the prescribed time period as laid down in the Assam Right to Public Services Act, and a final decision is to be communicated as per the procedure to the petitioner as per the procedure laid down in the Assam ARTPS Act.
That may be kept as a part of record, Lordship.
The copy of the letter, office letter number so and so dated 7/8/2026 of the District Commissioner Borpeta, placed by Mr. Sharma, is kept with the case record by marking the document X.
Item 5. Item 5, Lordship, we have been directed to obtain instructions. May I pray for some more time, Lordship? We have not received.
The District Commissioner,
Lordship.
to the Circle Officer of 26/7/2000. 6 years have gone by.
They are not doing it, your lordship.
Lordship, I will get it, Lordship.
What is your instruction?
No, today, Lordship, no instructions.
No instruction.
So I had the talk with the circle officer of the, and I have sent the letter to him, Lordship. We not yet get any instructions, Lordship. So may I please some more time?
So how much time?
Next week, Lordship.
Heard Mr. A. What Biswas Learning Council for the petitioners. A. aforesaid, then standing council, so and so, and Mr. Idlik Hassan, H. Formal and additional senior government advocate for the respond number 2 and 3. Mr. Sharma, and additional senior government advocate, has submitted that he has not yet received the instruction as regards their status of case number E-11350003 from the respondent number 3 and has sought for
But
further 1 week's time. I think a circle officer. Is it not? 3
Lordship.
further 1 week's time to make endeavor to produce the instruction regarding the present status. List the case on service.
A date will be fixed.
19th August, 1908.
Oblige.
Item 6.
My lord, I have written to the DC. DC is asking for another 3 weeks time to get instruction. Perhaps the entire affidavit will be filed within that time.
Heard Mr. A.R. Vinal, senior counsel listed by Mr. Anjit Chaudhary for the petitioner, Mr. A. aforesaid, and standing counsel, Revenue and Disaster Management Department for the respondent number 1, and Mr. A. Sharma, and additional senior government advocate, Assam for the respondent number 226. Mr. aforesaid, and standing counsel, Revenue and Disaster Management Department has submitted that he needs 3 weeks time to complete his instructions and to file
affidavit.
File a counter affidavit on behalf of the state respondents. Post of, in view of the above submission, let notice be issued. The notice is made returnable on so and so. As Mr. aforesaid 1, Sharma 226, no formal notice, extra copies within 2 working days from today. The earlier interim order passed on 37/2026 shall continue till the next returnable date.
14 September, 1409.
But from item number, my lord,
Sound?
6 to 9, my lord. 6, 7, 8, 9. 4.
Same. Parties are same?
Yes, my lord. Petitioner.
It was earlier interim order passed on 31/7/2026. Last one.
Oblige.
Item number 11.
Register of Society by involving section 24 of the Society Registration Act. Though I don't find any provision in Society Registration Act. There is no provision like by section 24. He sanctioned by section 20. But he has cancelled my registration.
Which order? By which order?
Page 221.
Mr. Sharma. Asking manual how and alleging arbitrary renewal of registration of society. So one of hearing registration number since the obtained renewal of registration something fake government.
Twenty-three.
What is it earlier order? Judgment?
Yes, ma'am. Page 132, ma'am.
Oh, last part. Last part of the order. Last paragraph.
Yes, ma'am.
So that impugn order, who is that impugn order?
Page 221, ma'am.
221.
21.
It cannot be. 221.
220 and a
It
13.
is very recent order.
Yes.
2018.
18.
Where is that?
Yes, ma'am. That one. It's 122, ma'am. Last, the earlier order, ma'am.
122.
Yes, ma'am.
So this order was set aside only on the ground that no opportunity was
Yes,
afforded, right?
Yes, ma'am.
So an opportunity is to be afforded and thereafter fresh order should be passed. Now,
So,
only thing is that a copy of the complaint,
Yes, ma'am.
an inquiry report of additional deputy commissioner
Yes,
to the
ma'am.
petitioner.
Yes, ma'am.
So was it complied with?
No, but the complaint was never furnished to me, madam. The complaint, madam, which was filed by the private respondent, that was being furnished to me, madam.
Huh?
Page,
No, page 131.
yes, madam.
That petitioner was this committee
Yes, ma'am.
represented by Sheikh Moinul Haq.
Yes, ma'am. Now, but in the present complaint, the complaint filed by the Sheikh Moinul Haq itself, madam. He was removed from our committee.
Now,
madam.
who filed the earlier complaint?
Mojibur Mullah, madam, the earlier president of the committee, madam.
You should notice at this stage, something is wrong.
Yes, ma'am.
Art Minister has brought forward learned counsel for the petitioner. Finance Department, Miss M. I.M. Borua. On behalf of whom? Learned counsel on behalf of Mr. A. Solia, Learned Standing Counsel Finance Department. For the response number 1, Mr. A. Sharma.
225.
Learned
2, 3, 4,
Traditional
5.
Senior Government Advocate Assam for the response number 225. Who is this? Petitioner and respondent.
One is committee, one is committee, madam. That is a
Huh?
dispute, madam. The petitioner is
Mr.
committee, madam.
Sharma.
Lordship. I have also seen lordship. petitioner
clear
is,
this
Yes, ma'am.
confusion.
one is committee, one is, name is same, one is committee.
But that is will clear, my lord, from my lord, page
We'll
52,
not
my lord.
look into.
Yes, ma'am.
You should notice. The petitioner has assailed an order dated.
13/3/26.
Registrar has found all are fraud.
Yes,
Take
ma'am.
society.
Because I did not appear before the registrar, my lord. Though I have submitted my petition.
Have you said at any time that in compliance of the earlier order, I have not been furnished with a copy of the complaint and a
Yes, my lord.
report of the additional
Yes,
deputy district
Yeah.
commissioner? Where is that? You should notice, has sailed an order dated 13/3/2026. Passed
Well,
by
page
respondent
212,
number, passed
218,
by the- by respondent number 2. Page
218, my lord.
200. When?
12/3/26, my lord. The order was passed on, my lord, 13/3, my lord. Before I
Oh,
sent a.
you also waited for 7 years. Without
Now, yes, ma'am.
that, look, Mr. Registrar, you have not supplied with a copy of the complaint. The report of the additional district commissioner.
But
So
what I
you
have-
waited for
No,
also
what-
7
can you
years.
see, my lord, what had happened, my lord? This complaint has been filed. The present
Everything
complaint
is,
filed by the.
something is not hunky-dory.
Yes, ma'am.
You should notice returnable on soil. So as Ms. Borua, 1, Pharma, 225, no formal notice, extra copies. Steps upon respond number 6 by a speed post. Notice returnable 6. Respond number 6 by speed post.
Hablas.
Item 12,
কেতিয়া দিলে?
6.
6.
May I please, your lords? The petitioner, your lordship, are in occupation of parcels of land, your lordship, ranging from 7-8 lesses to your lordship 1 kotha, your lordship maximum, since early 20th century, your lordship. This land was originally belonged to Gauhati company, your lordship. And since then, they have been their predecessors' interest, your lordship. We're occupying those lands, your lordship, by paying revenues to the Gauhati company, your lordship. I have annexed, your lordship, at page 113 onwards, your lordship,
For all?
for all.
All?
Lordship.
Have you, how linkage is from that original persons to
Lordship,
the,
linkages,
with the
these are the
family, with the,
documents.
have you done all the pattas or all the revenue receipts of all the persons?
No, your lordship, all the persons, your lordship.
All the persons?
All the persons.
And the family tree?
113.
Because 1912,
Lordship.
have you done the family tree exercise?
That, your lordship, we will have to file an additional affidavit.
File
but
it.
we'll-
Otherwise,
My lord,
out of how many are there?
No, your lordship. is to-
We have not issued notice earlier also.
Yes, my lord.
Lordship.
With regard to my lord,
Because many, there may be 300.
Lordship.
But unless with a statement that
Lordship.
this is my family tree,
Lordship.
my predecessor in interest is this one. He has held the patta or whatever.
Not patta, your lordship.
Whatever,
They were
whatever.
Lordship. They were tenants.
1912 or 1857,
Lordship.
right?
At various
But there
times,
has
your
to be the family tree.
Lordship.
it is, if your lordship come to.
Because court is not in a position to decide the.
But the issue here
If a
is.
statement is made on oath,
Lordship.
it is welcome.
Lordship.
Otherwise, court is not going to exercise its
Because a
fact-finding exercise.
new encroacher also has come up, my lord.
No,
That is a petitioner number.
Without strangers
Lordship.
in the process.
Lord.
Because we have found
Yes, my lord.
in the course of deliberation in many matters, petitioners are 300,
Lordship.
but documents are of 5.
Lordship. That
With
is
no
the-
linkage,
Lordship.
with nothing.
Lordship.
One document of something,
Lordship.
right?
No, we have annexed here, your lordship, And your lordship will kindly note, your lordship, there are allotment letters also, your lordship, in favor of these petitioners.
So better to have a chart.
Lordship.
This chart in
Lordship.
a tabular form so that it will facilitate the court.
Lordship.
Petition number 1 is, his right is traceable to which document
Lordship.
and through whom. Otherwise, how can the court sitting in?
No, your lordship, what has fallen from your lordship?
Yes.
Your lordship, I
So
understand.
that this is the historical document.
Lordship. That I will.
And
your-
this is my petitioner interest
Lordship.
to whom the historical document was issued.
Lordship.
And this is my family tree.
Lordship.
And I derived that right from this petition and from this historical document. Then it will be better for the court
Lordship.
to, otherwise, without table,
Lordship.
it is very difficult for the court because to handle 250, 300 petitioners.
We have your lordship, not
Let us
300.
see your case now.
Lordship. That I will do, your lordship. That your lordship.
Just
will-
because filing an application is very difficult.
Lordship.
Because many persons in a
Lordship.
batch of petitioners of 200, 300
Lordship. Here, your lordship,
get in.
43.
No, this is the trend we are seeing. Right. There are passengers in rail
Lordship.
with authorized ticket. And there are passengers in the rail,
Unauthorized
same rail with platform ticket. And there are
Unauthorized.
passengers
Lord.
without even platform ticket.
Lordship.
Right.
I understand your lordship.
So how a
Concept.
TT
Lordship.
can check all the, and without the strangers
Lord.
or the persons with a platform ticket also.
Lordship.
That is why.
Lordship. I will do that, your
Well,
my case,
Let me,
otherwise.
let me find out your case.
Lordship. My case,
Just
otherwise.
a minute. I'll read the first one, then I'll hear you. Just see your historical documents.
Lordship. First, your lordship, that is Annexure 2, your lordship. These are the documents, your lordship, which
Annexures 2 starts from
113, your lordship.
113.
13. The petitioners, your lordship, pay rent to the Gauhati Company Limited, predecessors and interest, your lordship. That again, I will have to
Whose predecessor interest? This man?
petitioners, your lordship.
No, which one? Which one?
That I will have
Do
to
you-
tell it.
Whether you know yourself
Lordship, that I.
that
I have
this
instructed-
113
Lordship,
is related to whom?
lordship. That I will have to.
Have you made any statement
I have made a para 3, your lordship.
that this is belong to whom?
That table has not been given here. That I will provide.
Do it.
Lordship, that I will provide.
Do it. Because you have annexed the entire this thing.
And your
Annexure 2.
lordship, I will in detail, I will file an additional affidavit. your lordship.
Make it a table in a tabular form.
Tabular form.
Right.
And your lordship may kindly come to page 167.
Yes.
Lordship.
Yes. 167.
This is your lordship, the proposal, allotment proposal in respect of 65 person.
Along with the document, you give the family tree also.
Lordship, I will.
How the link is established.
Lordship.
Yes, 167.
57, your lordship will find the,
Deputy Commissioner.
this is to the
Service,
deputy commissioner.
I have the honor to inform you that the circle officer has submitted allotment proposal in the name of Gopal Rai. 64 other state proposals were approved, subject to payment of.
Altogether 65, your lordship.
So this is meeting is in the proposal number so and so.
Zero. 2015, as per the 1989 land policy. Your lordship.
Okay, okay.
Now, your lordship,
Hello.
kindly come.
Therefore, the list determining premium below the state program is forward herewith. Please for the subject to deputy commission. Where is the meeting minutes?
Lordship.
Is it annexed?
We have not been
Okay.
given the copy of the
Okay.
minutes, but that has been admitted that by the
Okay,
authorities.
okay.
Page 175 is the, your lordship, letter from the Joint Secretary of Assam,
Okay,
which refers to the subject side. I am directed to send here with a copy of the letter under reference and request to kindly give some report on the present status of the lands and the eligibility of the applicant for allotment of government land, which will comment to this department further necessary action. Then your lordship will come to page 176.
hmm. Just a minute.
Six, your lordship. This is by the additional deputy commissioner, where your lordship, there is a specific reference to the subdivisional level land advisory committee meeting dated 23/11/2015. With respect to the subject and reference mentioned above, I have the honor to inform you that allotment proposal submitted in terms of so and so and 64 other persons were considered eligible and approved in the subdivisional land advisory committee held on 23/11/2015. The individuals are currently in possession and enjoyment of the said proposed land. The report of the letter sent from this office as mentioned in the reference has been corrected, amended, and forwarded here for kind of action.
You have these certificates also.
Lordship, certificates has also been issued, your lordship, by the additional from page 180 onwards, your lordship, in the name of the petitioners, your lordship. Serially, we have annexed. your
These
lordship.
petitioners.
These petitioners.
Okay.
On this petition. Lordship.
Aye.
Will be prescribed by the land policy, your lordship. Now, petition, it is in respect of petitioner 38, your lordship.
Page.
Annexure 8, page 208. The applicant has submitted an application for paying for allotment of the ceiling government land currently under their occupation. The applied land is located in so and so, consisting of piece of land, one lesser, which is a part of the ceiling government land.
So it was a ceiling land from
Ceiling land.
the tea company.
Tea company. Your Lordship. It was ceiling surplus, then your lordship. We originally, our predecessor interest are tenants, your lordship. Thereafter, in the 2015, as the LSC has decided to allot it to us, your lordship, allotment certificates were issued. And interestingly, your lordship, we have been, some of the petitioners are allowed to construct houses also by this municipal board, your lordship. Yeah, we have got permissions also, your lordship. And then, your lordship, what has happened? Page 229, your lordship. We have also come to honorable court earlier, your lordship, that I will have to point out. And that has been withdrawn in view of the subsequent development, Your Lordship, apprehending eviction, Your Lordship, since we're not giving us a settlement, Your Lordship. And then page 229 is the minute, Your Lordship.
That writ petition is pending.
No, Your Lordship, we have already withdrawn it subsequent to passing of the subsequent to the new development that had taken
Okay.
place, Your Lordship.
Yes.
Page 229, Your Lordship, will kindly see. This is the minutes of the meeting of the District Land Advisory Committee. Earlier it was SDLAC, Your Lordship. Now it is by the District Land Advisory Committee. Now the committee considered a petition of by Sri
Which
proposal number 2
proposal number?
at page 229.
Okay.
The committee considered the petition by Sri so-and-so and 40 others for
There were total 65 earlier.
65. Now
This petition, how many?
43. Complaint at Rajabari Grand Dag, presently occupied by 65 families without formal settlement, and proposal of Sonari Municipal Board for development of a municipal commercial complex over the same land. The circle officer's field inquiry report confirmed unauthorized illegal encroachment as earlier as the LAC recommendation was noted from 23/11/2025. It was unclear whether final golf allotment settlement order has been issued. Legal and policy position. Under ALLR 1886, the settlement rules government land cannot be occupied as of right without lawful settlement. Rule 18(2) provides for removal of encroachment subject to due procedure. The Gauhati High Court in so-and-so versus so-and-so held that notice is mandatory before Rule 18(2) proceedings. The Supreme Court held that the unauthorized occupation of public lands should ordinarily not be regularized with limited exception. The Assam Land Policy 2019 provides for settlement of eligible indigenous landless persons subject to eligibility criteria, land availability and competent authority approval. Mere occupation does not create title. Direction issued to Additional Deputy Commissioner Revenue to conduct in detail inquiry covering status of SDLAC proceeding dated 23/11/2015, whether any final golf allotment settlement order was issued, present status of land as per revenue records present, possession, identity of current occupants versus those considered in 2015, eligibility under Assam Land Policy 2019, Mission Busundhara, the municipal board's land requirement exact schedule, any applicable Gauhati High Court order, and whether claimant can be considered on the same or alternative land. The circle officer Sonari Revenue Circle to identify and submit a detailed report regarding suitable alternative golf ceiling surplus khas land if available for 65 units for homestead purpose to the executive officer Sonari Municipal Board to submit a detailed project report on the municipal commercial complex, including board resolution, concept note, exact land schedule, map, public necessity, funding source, administrative approval, alternative sites examined, and expected public benefit. Mere long possession of occupation of golf ceiling surplus land shall not by itself confer title or automatic right of settlement. If any occupant is found eligible under Assam Land Policy 2019 or other golf instructions, such case shall be considered strictly as per the law and subject to availability of suitable land and competent authority approval. Ineligible occupant or persons found to have recently encroached, transferred, sublet, and occupied the land in violation of law may be proceeded against under applicable provision after due notice, hearing, and reasoned order. Now, from this, Your Lordship, two things become apparent, Your Lordship. Basically, the inquiry will be, Your Lordship, whether new entrances come. And number one. Number two, Your Lordship, whether we are eligible under the land policy to get the settlement or not. Now,
That that has been wrongly mentioned.
Lordship.
This Takwal, this is not a VGR land, it is a ceiling surplus land. So that is not applicable. That is not the case. Wrongly quoted or wrongly relied upon. Salahuddin, if it is 18(3), it will be 18(3), not 18(2). Ceiling surplus land. Then what happens?
Then, Your Lordship, they have issued notice for hearing, Your Lordship, to us, the Additional Deputy Commissioner, page 231 onwards. submitted, participated in the submitted documents, including your lordship, certain your lordship, Jamabondi, showing that similarly situated persons has already been settled with the land parcel of land from the same tag, your lordship.
Have you received this circle officer report?
Lordship, that your lordship, that we have not received, we have not been provided with, then your lordship will kindly come to 241, the impugned minutes, your lordship.
Okay, in 240.
241. Proposal number 2 again, your lordship. If your lordship permits, may I read, your lordship. As per the decision recorded in the minutes of DLSC Choraideau held on 26/6/2026 at 12 noon, the additional district commissioner at Choraideau submitted a detailed enquiry report by number so and so dated 3/7/2026 in compliance with direction number 1 of the said minutes, which was placed before the committee by the member secretary. The salient finding of the reports are noted as under. In the course of inquiry, notices were issued to all 65 persons.
Just a minute, just. Teaching is the problem.
Lords. I'm sorry.
খালি বললাম পাইছো
Binding.
খালি বললাম পাইছো ঠিক আছে খালি গৈছে চাই লব কাগজটো ওলাই যাব যেন
Yes, 241.
Proposal number 2. But it is not recorded in the minutes of the DLSC Choraideau held on 26/6/2026 at 12 noon. The additional deputy commissioner, district commissioner revenue Choraideau submitted a detailed enquiry report by number so and so dated 3/7/2026 in compliance with the direction number 1 of the said minutes, which was placed before the committee by the member secretary. The salient findings of the report were noted under. In the course of enquiry, notices were issued to all 65 persons families figuring in SDLAC recommendation dated 23/11/2015 and preliminary fact-finding hearing were conducted on 30/6/2026 and 1/7/2026 for the limited purpose of ascertainment of the facts for the inquiry and without prejudice to any proceeding under Rule 18(2), in which all 66 occupants found residing on the streets, including one occupant not figuring among the 2015 recommendees, were heard along with the executive officer, Sonari Municipal Board, and the circle officer, Sonari Revenue Circle. Of the 66 occupants, 65 figure among the persons recommended by the SDLSC on 23/11/2015. 16 of the said recommendees have since expired and were represented by their legal heirs next of kin, while the remaining 50 occupants appeared in person. The recommendation of SDLSC dated 23/11/2015, though forwarded to the Govt of Assam by letter number so and so dated 30/1/2016, never received government approval and no final settlement order or patta was ever issued, and land continues to be recorded as ceiling surplus government land and the occupation is unauthorized. The occupants are carrying on business, commercial activities upon the land. None of them claim cultivation as a means of livelihood. Hence, prima facie, none answers the description of a landless cultivator under section 17(3) of the Assam Fixation of Ceiling on Landholding Act 1956, read with Rule 8 of Settlement Rules, and the claim of the Sonari Municipal Board for development of a municipal commercial complex tracing to the allotment made in favor of the erstwhile Sonari Town Committee by SDLSC Resolution number 9 dated 31/8/1984 relates to the self-same parcel and sense on a higher footing as a public purpose. During deliberations, some members raised the query as to whether any periodic patta holders among the persons called during hearing. In reply, the additional deputy commissioner revenue clarified that as verified from records and depositions, all the persons called for and heard in the inquiry, with the sole exception of one occupant, Sri Ziauddin, son of so-and-so, are holders of allotment certificate issued pursuant to SDLSC meeting held on 23/11/2015 as reported. No periodic patta subsists over the scheduled tasks which continues to be recorded as ceiling surplus government land. The clarification was noted by the committee to its satisfaction. Legal and policy position noted. The committee noted the legal position set out in the inquiry report, namely that under ALRR 1886, the settlement rules, government land cannot be occupied as of right without lawful settlement, and Rule 18.2 provides for removal of enforcement subject to due procedure, that the Honorable Gauhati High Court in so-and-so versus so-and-so has held that notice is mandatory before Rule 18.2 proceeding. The committee specifically noted that the hearing afforded during the inquiry of the ADC was preliminary fact-finding exercise for the purpose of inquiry alone, as it is distinct from and does not substitute the mandatory notice and opportunity of hearing under Rule 18.2, which shall be separately and independently complied with more before any removal of occupations, that the Honorable Gauhati High Court in Manikuddin and others versus State of others, judgment that is so and so, has held that even an approved SDLSE resolution remains subject to verification of eligibility and of possession and crystallizes no right a fortiori, where as here government approval was never received, that the Honorable Supreme Court in Jakpal Singh and others has held that the unauthorized occupation of public land should ordinarily not be regularized, and long possession, construction, raised or expenditure incurred furnish no ground for regularization. The public land is held in trust for the public, and that the Honorable Supreme Court by order dated so and so has approved the mechanism notice consideration of occupants evidence and reason speaking order granting reasonable time to vacate as satisfying due process in removal of unauthorized occupation. The Assam Land Policy 2019 Mission Basundhara provides for settlement of eligible landless persons subject to eligibility, land availability and competent authority approval. Mere occupation creates no criteria. Cancellation of the SDLSE recommendation dated 23/11/2015. Having considered the inquiry report and noting that no approval was ever received from the government on the recommendation of SDLSE dated 23/11/2015, and the said recommendation consequently never matured into any settlement, the chairperson declared with concurrence of the committee that the said recommendation together with allotment certificate issued pursuant here to be and stand recommended for cancellation, that this declaration shall be enforced with immediate effect, no right, equity or expectation being claimable on the basis of said recommendation or certificates hereafter. The matter shall be reported to the Government of Assam, our Revenue and DM Department for formal orders as required. Removal of unauthorized occupation and handover to the Sonari Municipal Corporation. Upon considering the inquiry report and the request of Sonari Municipal Board, the committee resolved that the scheduled ceiling surplus government land and Rodabari grant be restored to unauthorized government, unencumbered government possession and rendered free for all income occupation for the said purpose. Press and separate proceeding under Rule 18.2 of the settlement rules framed under ALR 18.6 shall be initiated against this occupant. The preliminary fact finding hearing conducted during inquiry being distinct therefrom by issuance of individual so-called.
Yes, subsequent to there to.
Then your lordship 18.2 proceeding has been started. We have been issued notice, your lordship. Now, your lordship, there, your lordship will kindly note two things, your lordship. First of all, your lordship, this order, minutes, your lordship. What is the finding of the inquiry by this ADC, your lordship? That has not been disclosed. The parameter that has been fixed by the earlier district level committee, your lordship, so far as the inquiry by the additional deputy commissioner is concerned, whether we are eligible or not, that has not been discussed at all, your lordship. And secondly, your lordship will kindly see, once this land allotment committee, your lordship, take a decision whether, and that decision is presently pending before the government, your lordship, and government has sought certain information from them as far as the eligibility and other is concerned, your lordship. Now, whether, your lordship, this committee has, your lordship, power at all to review the decision of the earlier committee, your lordship. Ultimately, they are reviewing the earlier order, your lordship, earlier recommendation, your lordship, and there will have to be some sort of, your lordship, power vested on them to review that order, your lordship. Where from they get that power, your lordship? This is and your lordship, they are to see whether we are eligible or not, and they have said that we are unauthorized occupant, your lordship. But from 2015 onwards, at least we are not unauthorized occupant, your lordship. based on certain allotment certificate issued by the competent authority, based on recommendation by another authority, Your Lordship, we are.
Just a minute.
Lordship.
So 2015 is the SDLAC process,
Lordship.
right?
Lordship,
That is Annex 3 series onward.
Lordship.
And in between the earlier document, Annex 2 series, there is a big gap.
Lordship, that is a gap, Your Lordship.
There is a big gap.
At some point of time, once Your Lordship, it was Your Lordship, become government land, Your Lordship. Therefore, Your Lordship, there is no way to pay the rent to the original, Your Lordship, patta holder, Your Lordship. That is Gauhati company, Your Lordship. Therefore, there is a gap.
So since when you were submitting Bedokholi Jorimona,
Your
Koti
Lordship.
Bahira?
So far as Your Lordship, the question is Bedokholi Jorimona to keep up this one.
That is 1978. There is a report.
That is Your Lordship. Letter of the Deputy Commissioner in 2016, which says that we are eligible to get, Your Lordship.
What is the hierarchy of SDLAC and district level advisory committee?
Now, Your Lordship, SDLSC is not in existence.
District level.
District level. Earlier, it was SDLSC, then SDLSC. So far as the subdivision are concerned, it is done by the SDLSC already. Now, SDLSC is not in existence.
Entire thing is done by district level advisory
On
committee.
district level. And that is as constituted as per, Your Lordship, 1989 land policy. Your Lordship.
Now, against this notices,
Lordship.
what you are challenging here?
Here, Your Lordship, these minutes, Your Lordship, we have challenges, Your Lordship, whereby, Your Lordship, earlier decisions have been cancelled, Your Lordship, or withdrawn, Your Lordship.
Annexure 16 has been challenged.
Annexer?
16, Your Lordship, also, Your Lordship, these.
That is at what?
251.
Two. Your
16.
Lordship, 16 and also 17, Your Lordship, those notices, Your Lordship, so-called notices, under Rule 18(2), Your Lordship. This report of the additional Deputy Commissioner, Your Lordship, we had made a specific statement, has never been handed over to us, Your Lordship,
Which one?
including the circle officer. That report, Your Lordship, based on which this order has been passed, Your Lordship. We have made a specific averment, Your Lordship.
This is page 106, Annexer 16,
Lordship.
241.
41.
This is a step towards the finally.
Finally. Now, Your Lordship, finally.
Some resolutions are taken,
Lordship.
but question is regarding your right to be settled or allotted
Lordship.
versus state's right
Lordship.
to make the eviction free.
Lordship.
So these are the processes in between. But what documents, suppose in this notice, they have relied upon some report. Recommendation, this SDLSC recommendation, do you have? So if you-
2015.
Uh,
15 we don't have.
So if you are something they have relied upon, which you have not been in possession, is there any list? Suppose something, they have prepared report.
Lordship.
Report contains some fact finding inquiry. On the basis of they have proceeded to issue these notices.
Lordship.
Now, have you got the effective opportunity to rebut all these allegations by getting all the relevant materials.
Not, your lordship.
What are those?
No, first of all, your lordship, the report of the circle officer, your lordship, additional deputy commissioner, which forms the basis of the minutes at for page 241. Now, your lordship will kindly see another aspect, your lordship, page 210 for a moment, your lordship. 210 for a moment. 210. Article 5, that the by 210, your lordship, the government has sought from certain information from the authorities. That means, your lordship, the government is cessation of the matter, your lordship. And they have not passed any order, your lordship, either rejecting or, your lordship, allowing, your lordship. And these are whether the land is free from any litigation, whether any revision petition is pending before the collector of government in respect of the proposed land, and date of passing final statement showing the land compensation case, your lordship. Now, that means, your lordship, the government was still cessation of the matter when they have on its own taken a decision, your lordship, whether it could done it.
Yes, Mr. Bhattaku, otherwise, you know the show cause notice stage.
Lordship, I know. Lordship.
Show cause notice stage, this is a step. Law is that show cause notice, just to ascertain, is a step towards a final decision.
Lordship.
And if the noticee can meet the case and rebut the charge, then the final decision can altogether be different.
Lordship.
That is the position to interfere the stage of show cause notice, because one proceeding is going on. So if you are deprived of meeting the case of the respondents, any list of documents you need to represent your case, do you need some documents? Because it is a show cause process.
Lordship.
You have been issued a show cause.
Under
Right.
18.2, your lordship.
Something has been carried out behind your back, suppose, right? And you have not been allowed a copy of all those documents, or you need some documents which are in possession of the state respondent, right? Then with those documents, you can rebut the case
Lordship.
set up by the state
Lordship.
in the show cause notice.
Lordship.
Suppose this will not be a case of 18.2.
Lordship.
It should be a case of 18.3.
Three. Lordship.
Because this is a thing in progress.
Lordship.
So that is what I am, because interference with a show cause notice
No, your lordship.
is a serious issue.
No, your lordship, I what has fallen from your lordship, I have
Right.
understood, your lordship. But the point is, your lordship,
If you have, if you have
our
on a good case, you have a better case than many others.
lordship,
I'll not say
Lordship.
this way or that way, but you have to effectively respond.
no, we will, your lordship. But the point is, your lordship, the very foundation of our case has gone, your lordship, with the cancellation of the earlier
That
allotment
is what I am.
certificate, your lordship.
That is why I am asking.
Lordship.
These are whether they are functioning, they are discharging any statutory role, or they are a recommendatory body under the land policy.
No, they are
Because this hierarchy thing,
lordship.
because they are not bodies under the Assam Land and
No.
Revenue Regulation or
It is-
settlement rules.
It is by the deputy commissioner.
It is under the provisions of the land policies.
Land policy. Under
These
the-
bodies are under the land policies.
Not the statutory body.
They are not discharging any statutory function. They are under land policies.
Land policy.
Statutory function, hierarchy, SDLSC over that, suppose district level.
Lordship.
If the power is there, they can revise. If power is not there, they cannot revise. But they are not statutory bodies.
Lordship.
They are bodies envisaged under land policies.
Lordship.
Now that issue you have raised, that whether they can revisit,
Lordship.
that is relatable to that issue.
Lordship.
That is why I am putting this question to you.
Lordship.
They are merely bodies. And until it is finalized or by the state government,
Lordship.
everybody can make recommendation.
Lordship.
Everybody in a file, in the processing of the file, there will be 5 different opinions.
Lordship.
But it is the state
State
government
government.
who can have the final say.
Lordship. That is why I have pointed out
Right.
210.
So that is why I am asking you, what is the force in your submission?
No, your lordship, that is why, your lordship, I am submitting, your lordship, when the appropriate government is, your lordship, citizen of the matter, whether they can suddenly come up with a
On that itself, I am asking this
Lordship.
question. Right, from the basis or many, that everybody
lordship,
in the process of decision making make his own opinion,
lordship,
right? But it is the final say will be of the ultimate authority,
lordship,
right? It is, which is the state government,
State
the
government.
revenue department,
lordship,
right? They have made something, recommendation, and they carried forward. Now that is what I am asking, that what is the force? It is pending. They have not decided.
not decided.
They have not decided.
Decided.
But whether it will preclude any higher body,
Lord.
say from SDLSC to district level advisory committee, to give its own opinion and to process further.
In my humble submission, your lordship.
Because no statutory backing.
No, your
both.
lordship, absolutely. your
Both are
lordship.
recommendatory bodies.
Lordship. In my humble submission, your lordship, in a case like this, your lordship, where your lordship, these recommendation has translated into certain actions, your lordship, and thereafter, your lordship, this has been forwarded to the carry forwarded to the government, the ultimate authority to take a call on that, your lordship, without waiting for the final call from the government, your lordship, the district level committee, your lordship,
So far, yes. Otherwise, so far as competence to issue
lordship,
a show cause notice, like 17/7/2026,
Lordship.
that is beyond doubt.
lordship,
Circle officer can issue
your
a
lordship.
notice,
Lordship.
and you have to respond to it.
lordship, we will, your lordship, but
And that is why because you have shown so many documents,
lordship,
and there may be some other documents which will crystallize your right,
lordship.
crystallize the right in your favor. Are you deprived of those documents?
No,
That is-
one document I have already pointed out, I have made a statement, your lordship, the report.
Even
that
if
has
you,
not been
even if
provided
you,
for.
even if you have submitted a representation,
Lordship,
but if you are still in need of making a further representation, comprehensive representation, with the support of all the necessary documents,
lordship,
then we can have it.
lordship.
But otherwise, you have to respond it.
No, I will, your lordship, that we are more concerned about, your lordship, not that, your lordship, the resolution adopted in the meeting, and pursuant to that, your lordship, unless, your lordship, that resolution goes, your lordship, our whole case is gone, your lordship. Now we automatically become unauthorized occupant, your lordship. That is the prejudice that has been caused to us, your lordship.
Let us have the land policy.
Lordship, in 1989.
What is the role of this?
Land Advisory Committee, your lordship.
Oh,
That your lordship will get it at
that's it, page 17.
page, your lordship, last at the Land Advisory Committee, your lord, 19, clause 19.1.
We shall discuss.
made, this was the only highest authority, Your Lordship.
So advice was to Deputy Commissioner and subdivisional officers
Lord.
civil in the matter of allotment or settlement proposal of land in a district or subdivision.
Lords. They have advised
Ah.
on the basis of their
Land
advisory.
Advisory Committee shall discuss, review
Lordship.
and suggest. So
Lord.
review power is there.
Lordship.
It is not that it
Subdivision
is
of
not
the
there.
case may be in the matter of
Shall
allotment.
discuss,
In the framework of land policy relevant.
review and suggest.
Lordship, including chairman, which one, Your Lordship?
19.2.
19, no, there shall be also a special advisory committee council member, deputy commissioner, Kamrup, Your Lordship.
89.
Oh,
We are in
okay,
19.
I am on 89.
Huh?
This was, Your Lordship, our allotment was based on 18.
But
89.
as
Now
long
it
as
will
this
be
is
gone
the,
by 2019.
this is holding the field.
Now this is holding the field,
Huh.
but when the recommendations were made, Your Lordship, in 2016, 1989 land policies were holding the field and subdivisional advisory committees were the, Your Lordship,
But it is, they can
2019
discuss and review
No,
and
that-
suggest.
that is in 2019, Your Lordship.
Yes,
Yeah.
because when it is not finalized,
No, Your Lordship, that's fine.
Now, my lord,
And
because
then
I have, because I am saying because I am bound by my own
Your
decision.
Lordship.
Right, I have held that unless it is after premium also, fixation of premium also by the land advisory committee, then he also deposited, but ultimately it is the state
Same
government who has to decide.
14.3, my lord, it will make clear. 2019, my lord.
Now, before 2019, Your Lordship may kindly see
We'll
1989.
see, we'll see. 14 point?
Was 14.3, my lord. 2019, my lord.
Mary? Town area.
This land falls on the town area, my lord.
This is town area.
Town, Sonari town.
Town.
Town
Okay,
area.
okay.
That is, Your Lordship, this is, Your Lordship, no quarrel with this. The government can, Your Lordship. And Your Lordship has held and recent judgment also held, Your Lordship.
It says, my
Simply
lord,
because of my occupation, I cannot claim.
will
But it
not
is-
consider settlement of any
Okay,
government
clearly.
land or town under possession.
Yes, which provision of the 1989 policy?
89, Your Lordship, 19.1, Land Advisory
Ah.
Committee. As per 19.1, Your Lordship, it was the subdivisional level committee, which is the authority, Your Lordship, to advise the deputy commissioner. And Your Lordship will
Because
also,
the decision there, because the this under 19.2, they have the power to discuss, review and suggest.
that is 19 policy.
Ah,
And Your
they can-
Lordship,
they can change the view.
no, they can, Your Lordship will kindly
So
come
to
to
229, page 229, resolution number 2, or proposal number 2.
Now, Your Lordship, when assuming for a moment that Your Lordship, they have the power, Your Lordship. Now, Your Lordship will kindly see, Your Lordship, the earlier minutes, Your Lordship, where what will be the what will be the parameters of the inquiry, Your Lordship? Parameters of the inquiry that has been very clearly mandated, Your Lordship. Have they discussed, Your Lordship, in the subsequent, Your Lordship, minutes that, Your Lordship, whether we are eligible or not, Your Lordship? That was there, and Your Lordship will kindly see 1980.
Oh, page 229, Mr.
Lordship.
Kotagur.
Lordship.
Your eligibility under the Assam Land Policy 2019 and Mission Basundhara,
Lordship.
that was a subject matter of inquiry
Lordship,
by the additional
Lordship.
district commissioner,
Lordship,
right? There may be finding of facts,
Lordship,
right or wrong.
Lordship,
Right or wrong might be against you.
Lordship. No, that is what your
The
Lordship,
question
they should
is,
have, they should have discussed in the second mind with your Lordship, where they have taken a decision.
Page 242, my lord.
242, your Lordship.
these are, whether these are enforceable in law. These
Now
are,
your Lordship will kindly see that your Lordship, they have, and your Lordship, from the very beginning, your Lordship, we are not, your Lordship, illegal encroachers, your Lordship. We were tenants, your Lordship. And 1989 land policy says, your Lordship, for a moment, if your Lordship takes 1989 land policy, your Lordship.
the question is interference at the stage of so-called notice.
No, your Lordship, I understand, your Lordship.
Right.
I understand.
It is not that after so-called notice, final findings are recorded. We can interfere into whole hog. That all these are non-application of mine. But question is about interfering with a so-called notice.
No, your Lordship.
He has the competence to issue the so-called
No,
notice. It
your
is
Lord,
not a
that-
case of
Un-
lack of jurisdiction.
No, your Lordship.
Right.
Absolutely. Your
So we are also, because the law is also there that so-called, we don't so-called notice.
No, your Lordship, I
Lack of competence, okay, you interfere. Right. But here is a case, that is why I am trying to find out from you that whatever document, what documents you further need to respond to the so-called notice.
No, that your Lordship, I only need your Lordship so far as documents are concerned, that report of the circle officer, your Lordship, they have relied on, your Lordship, that is one document. Now, otherwise, your Lordship, rest of the documents we have furnished and we have in our possession, your Lordship.
Are your replies are here
Lordship.
to the so-called notice?
No, we have not yet replied, your Lordship.
You have not replied.
Not replied, but we will reply, your Lordship. There's,
Huh.
but the point is, your Lordship, if your Lordship, this resolution remains, your Lordship, the very foundation of our
Mr. Votagur, whatever is the resolution, whatever, but the question is about competence to issue the so-called notice.
Lordship.
That so-called notice is, competence is there.
No, your Lordship, that is why, your Lordship, that may proceed, your Lordship. But in the meanwhile, your Lordship, what happened to
No,
this?
question is about parallel proceeding.
No, your Lordship.
All this can be taken into, it is open for you to raise all these grounds
Lordship.
at the end of the final listing. But why parallel proceeding should be maintained?
No, so far as your Lordship, this particular resolution.
No, that will stop everything. Something is in Sejin of the High Court.
Lordship.
Everything is stopped. What is not to be made directly cannot be made indirectly.
No, your Lordship, then your Lordship, what will happen, your Lordship? Ultimately, we will become unauthorized
No, you can.
occupant.
No, it is
Because
married-
they will consider this and say that since this has already been, allotment letters has been cancelled, you become unauthorized occupant. Therefore, under 18.2, we will have nothing to say, or under
which has
18.3.
been cancelled.
Lordship, that's
Which has
the,
been, which
that's
has
the
been cancelled?
concern, Lordship.
Which has been cancelled?
Allotment has been cancelled, your Lordship, pursuant to this. They have taken a resolution.
Why is that?
Lordship,
241.
243, your Lordship will kindly come to. Cancellation of SD recommendation having so and so.
Which page?
Page 243, your Lordship.
243. Yes.
And the said recommendation consequently never issued into any settlement, the chairperson declared with the concurrence of
Cancellation of SDLSC
Lordship.
recommendation.
That the said
That is
recommendation.
243 discussion, decision and resolution.
Lordship. It is very clear that said together with the allotment certificate issued pursuant thereto. Otherwise, we would not have come before this honorable court at this stage of so-called notice, your Lordship. Had there been no such decision. Lordship, allotment certificates, sir, your Lordship will get it at page
Starting from 248, my lord.
179.
179.
179 to 207, your Lordship. Focus notice, the foundation of the focus notice is that, your lordship. Kindly come to page 249, the focus notice, your lordship. Given their findings, your lordship.
Now come to paragraph 7 also.
Para 7 of your lordship. Focus notice.
This is without prejudice.
Right, if you are genuinely landless and otherwise eligible to be considered allotment of alternative government land.
If your lordship come to the impugn minutes also is very clear, man.
Now your lordship will kindly imagine the situation condition, your lordship.
No,
They have.
that is why I am giving you
No,
time.
no, no.
Otherwise, I would not have given you time so much.
No,
Mr. Botakur,
Lordship,
it is not, don't, I am trying to find
no,
out.
no, that's, I am not.
We have to see into the niceties of law also.
Lordship.
And I am giving you so much time. Don't,
I bow down. I bow down. I'm not saying that what my condition that I am just trying to.
that is why I am looking into it.
No, not.
Giving so much patience.
Authorities. I am talking about the authority.
I am trying to, that is why I am giving the time.
I just want to show that, your lordship, they have issued, your lordship, permission order also, your lordship, town committee. We constructed houses. That's what I am, that to what they have put me, your lordship.
Because 2015, 16, and there was a big gap. It is not a continuous thing from your petition.
From 2017, there is nothing, your lordship. 2017 is.
Prior to 2015, and it relate back to something which is.
Lords.
It is not that I don't know the history also. I also know a bit of history.
I bow down, your lordship.
I will not, because I will not say that doesn't mean that, but I am trying to examine your case.
Lords.
Okay, we'll come back. Because some observations made here and there will not change the situation. SDLAC, all these are recommendatory bodies. And they have said that subject to recommendation, how can resolution, cancellation, having concluded an inquiry for an on the recommendation of SDLAC and the side considering never matured into settlement. With the content of the state and there to understand
Cessation of Sealing and Nail Holding Act, Your Lordship.
Yes, Mr. Das. This come to 41, your first resolution. Resolution number 1.
My lord.
243. Right. And then the matter shall be reported to the Government of Assam Revenue and Disaster Management Department for formal order as required.
Formal orders as required. my lord.
Right.
Yes, madam.
Now come to page 245. So basically copy to for necessary action.
Yes, madam.
So anything has been fructified.
My lord, on view of this, my lord, notices were issued under section 18 to my lord.
No, this formal order,
Yes, my lord.
that is for with the concurrence that the said recommendation together with the allotments certificate issued pursuant thereto and stand recommended for cancellation.
Recommendation for cancellation.
And that this declaration shall be enforced with immediate effect. So recommendation is in force
Yes, madam.
with immediate effect,
Yes, madam.
right?
Yes,
The
madam.
matter shall be reported to the Government of Assam Revenue Disaster Department for formal orders.
Formal orders.
So whether
The formal order is passed or not, madam.
without the
Formal orders, madam. That is
without the approval of the, because 245, they forwarded the matter for resolution number 1 specifically. Necessary. Right. And if it is received approval perhaps, then the action under this so-called notice would proceed.
Yes, madam. That's true. But
Because otherwise they would not have written
my lord,
formal approval.
there must be some formal order.
If that is all, then it is okay. If it is not all, that is not there,
Moreover, my lord.
perhaps that is why, I don't know, it is
Yes, yes.
for
Since-
you to say.
Yes, yes, my lord. I can get the instruction on that, madam. Whether a formal order has been passed or not.
Yes, for formal orders as required.
Yes, sir.
We may not know all the formalities.
Otherwise, annexer 17 cannot come.
Annexer?
17? that
Yes,
is-
may not.
May not. My lord,
May not.
Moreover, all that is there, my lord, but submission made by my learned friend also, my lord. If your lordship come to the case of the subsequent.
Because it is a competence only. We are not into this, otherwise they have to respond. Only thing is competence. Competence is there otherwise, but whether that competence is derived from the this resolution or it requires government's approval to proceed.
Why?
Because there was the SDLSC
It has been recommended
that was deliberated upon,
whether
and to overturn that
2000.
might require government's approval. To overturn that,
Yes, I understand.
that much only. Yes, madam. It is, it really requires government's approval to overturn an earlier decision of another land advisory committee. Otherwise, they would not have written it.
No, my lord. That is a totally different, my lord. It will come under the policy of 2019, my lord. 14.3 is very much clear. My instruction will be if what lordship just made, whether any formal order has been passed with regard to the impugned resolution, my lord. That is 241. If that has been passed, then
240?
241, my lord. Annexer 16.
Yes.
Yes, last.
243.
Yes, my lord. If not, then my lord, annexer 17 won't come.
That is what, for formal order to the, it was matter was reported matter shall be reported to the government of Assam.
For compliance report
Revenue
before the
and
comment.
Disaster Management Department for formal orders as required.
Yes, my lord.
Now, last part 245,
Yes,
copy 2. It is very specific to reference to resolution number 1 above.
Yes. That's it. That's what I'm submitting, my lord. If no formal order, automatically
Maybe.
annexers, yes, my lord.
Could be.
17, annexer 17 won't come. But what I think and what I presume, my lord, I may be wrong. I think there's just formal order.
Let us have,
maybe.
we'll come back. Let us have
That's
it.
my lord.
We'll come back.
Only that. Otherwise, it is covered by 2019 policy. Myself.
We'll come back after. Firstly, Mr. Botakur, you have to submit the additional affidavit,
Lordship, that I will.
giving your linkage to the historical document at page annexer
2, your lordship.
2 series,
2 series.
because we don't know the name even.
Lordship, we will do that. That we should have done, your lordship, but somehow.
Moreover, my lord, the annexer 17, there are some
And so far as your right from flowing from 2015,
Lords,
there is no doubt.
lords,
But prior to that,
lords.
you need to have at least from 2001. That is, the bridge is to be crossed from 9 or historical document and in between. And what is this, Mr. Das?
My lord.
The earlier
Page, my lord.
page 167.
This is the, my lord,
That resolution, copy of the resolution. Or you can get, have 172,
17.
Original.
original one. It is actually not pages, but pages, 22 pages. It is page number 22.
Lords.
Allotment proposals.
It should be page number 2. This is the আমার translation to global.
Bodoloi, regarding your formal order. Because it resulted into allotment certificates. Earlier proposal. Right, from the additional deputy commissioner revenue means deputy commissioner himself. Then that is why to overturn the decision of the earlier recommendation of 23/11/2025, a formal order, they said a formal order is required, whether there is formal order or not. Then it will be dependent upon the competence to issue this so-called notice, maybe. So you get all those document instructions in the meantime. Mr. Botakur will file the
I will.
additional affidavit. In the meantime, I will ask whether in terms of the resolution number 1, any formal order has been passed by the state government.
Yes.
Third, Mr. S. Botakur, and Senior Counsel, State by Mr. P.M. Muhammad, Learned Counsel for the Petitioners, and Mr. N. Bodoloi, Learned Standing Counsel, Revenue and Disaster Management Department for the respond number 1 and 2, and Mr. N. Das, Learned New Government Advocate for the respond number 3 and 4, full stop. Para. Petitioner, the petitioners, 44 in number, have joined together to prefer the instant petition stating that they have a common cause of action. In that, all the petitioners have been served with show cause notices under Rule 18 of the settlement rules framed under the Assam Land and Revenue Regulation 1886. Notices dated 17/7/2026. First off, by the show cause notices, comma, the petitioners are called upon to show cause, comma, in writing, comma, as to why they should not be removed from the scheduled land, and the land should not be restored to the government. First off, one of the contentions raised for the petitioner is that at an earlier point of time, on 19 11/2015, the subdivisional and advisory committee where is the minute? It is not available. The 2015 minute. Recommended. For settlement of the plots of land in favor of the petitioners. And on the basis of the said resolution of the SDLSC dated 23/11/2015. The plots of land as, comma, as mentioned in the allotment certificates, comma, as annex 2, annex 7, series periodic petition, comma, were issued in favor of the petitioners. It is a further case of the petitioners that জমাবন্দি
Similarly situated.
certificates, the petitioners are in continuous occupation of those plots of land, comma, the district level advisory committee in its meeting held on 26/6/2026. to be unauthorized operation of insurance based on a preliminary report dated 23/6/2026. Cycle officer. Promotional Revenue Circle. And associated. Resolved. Right, resolution number 1. In its subsequent meeting held on 3/7/2026. Okay, recommendation. To cancel. The earlier resolution dated 23/11/2015 of the SDLAC. So as per the resolution number 1. Said resolution number 1, comma, the DLAC. Sorai, comma, Sorai. Has reported the matter to the government for formal orders. Full stop. Subsequent to the said resolution number 1. To the patients. Based on the previous. Without formal orders. Of the government. Comma, RT. Did not happen. Proceeded by the PLC. Enough. On resolution of the material from comma. It's of this that. With the what is this mean? Purportedly issued between 1928 onwards. Person who paid. By the State Government Disaster Management Department. Number 1 adopted in its meeting dated 3/7/2026. After warning.
May I pray for some protection, Your Lordship?
You're filing the
I will-
response or not?
Response we will file. Your Lordship. Because Your Lordship, flood has in the meantime came, Your Lordship, that has.
17/7.
Yes, my lord, this is from Saraidos, Sibsagar district, my lord.
It's badly affected.
For idea.
Lords.
He could have said so, then I did not realize that.
Page 288, we have annexed some photographs also. 287. How they enter town.
This is not the proper time. It should not have been the time.
Yes.
This timing is bad. Then I have not seen that. I did not realize.
Moreover.
I would not have spent such time. At least
17/7.
This is not the proper time to take such action.
17/7.
Days before the flood.
Hmm.
19 days, my lord. 4 days.
Okay. Try to get it, otherwise we'll issue notice and we'll state a proceeding.
Lords.
We'll state a proceeding. Try to get the linkage
Lords.
next week, same date, Monday.
Lords.
Only the case
17th
now.
August. 1708.
This should not be the time.
I pray for some more time.
Then we'll issue notice. We'll pass appropriate order. Make the endeavor.
She has expressed the view of staying, that's why I.
We'll think about it on the next date.
Till next.
Lords.
A copy. Mr. Mohammed, learned counsel for the petitioners, shall furnish a copy of the writ petition along with annexer to Ms. Bodole and to Mr. Das, and during the course of the day.
Lords.
Me as well.
1708.
We'll pass the order. You could have said so that this is the situation in Sonari. I did not realize. We are only into the facts. This is not the proper time
Yes, my lord.
to
We
take
agree,
such
madam.
steps. Anyway,
Item 13.
yes.
Last week, copy has not been served to government, my lord.
Hmm?
Yes, though we have been a party, my lord. But neither to PWD, my lord.
Okay, hard, Mr. Aforesaid.
It has been served to revenue, though revenue is not a party item. Revenue is not a party.
We don't know also what is the project.
State government is in party.
3-4, my lord.
Mr. Rashid, what is the project?
Assam Mala.
Forcing the Assam Mala. there is a-
Assam Mala, right? There must be a name.
Yeah, so I also told me that by then that is there.
Huh?
That is Assam Mala. I have this-
Which road?
Assam Mala road. so there
No,
is-
Assam Mala is a scheme, not road.
Assam Mala, there will be 1,000 project. Which is the road? Then how can they obtain instruction also? Let us see. Purchase a plot
Only
of
blood
land,
annexer-
Sunamoni
annexer-
by registered deed.
Annexer 6 million, sorry, D.
Annexer
Annexer 6, sorry, Annexer D, page 20 million.
is 20.
That is million our. Last time that Your was.
Competent authority.
That was not party million, so now we have made him party. Kala.
Yes, very difficult for the court.
I have gone through little bit. I think 76 will come into play, my lord, because they were not against the amount fix.
No, we don't know whether which under what provision.
Yes, yes.
Mr. It will be very difficult for you to argue in the subsequent point of time. Heard Mr. A. Rashid. We'll also issue notice in Bhekwam.
In the middle.
No project.
He can withdraw and file it as refresh, my lord. That will be better for him also.
Very lesser details. We'll issue notice returnable on so and so or otherwise issue rule. This is very difficult for the court to spend time with this kind of petition.
Revenue is also not be the participant. It is required for the bank occupation matters.
We don't know what kind of project it is, RFCT, LARR Act or National Highways Act, or it is direct purchase, nothing. And not even the road.
Details are not.
If it is 2013 Act, it will be Deputy Commissioner.
Yes.
If it is National Highway, it is Additional Deputy Commissioner. If it is direct purchase method, it is different authority.
It's a direct purchase, but little bit.
We don't know where is that.
Then again, Millet, I am somebody that the fresh will taking fresh statement and fresh
Huh?
instruction. Sorry, fresh instruction I'll take Millet, I'll find again. Liberty, otherwise will not.
At least the road.
No, I understand that. Yes.
Which road?
Some
For which road
Some
your
road.
land has been acquired, right?
some
Because
Lekono is-
there is a dispute between you and some private respondents.
some Lekono is me with me, Millet. You understand that? Like
That much I have understood. But under which act? There must be a notification, right? You give just annex one notification, then we can pick up the other things. Just give a notification, annex it, then we can find out, we can call Mr. Das, Ms. Bordoloi or PWD to get the instructions.
Suit was filed.
Now,
And basically, it is a matter which is where a direction is called to the authority land acquisition officer Scala to refer the matter to the. That much I know, but
From where, my lord? Which road? Everything is.
which road and whether it is pending before Kala or land acquisition officer to refer it to the principal civil court of original jurisdiction.
District judge.
The final order I know,
The details.
but the details are not there. Mr. Rosida, I know this court knows what final order is to be passed.
I also know your lordship.
That there is a dispute between Mihir Kanti Das and the Onima Das and her family. And the matter is to be, the amount has been assessed. Now there is a dispute who is entitled to get amount or how much of it. For that, it is to be referred to, but nothing. Heard Mr. Rashid, learning counsel for the petitioner. Revenue is not a party. MDAS, Lion Standing Council, Public Works Department for the respondent number 1 and 2. Mr. MDAS, Lion Junior Government Advocate Assam for the respondent number 3 and 4. Poster. Mr. Rosid, Lion Council for the petition has submitted that he needs some more time to obtain the particulars about the project in respect of which the plot of land in question has been acquired. Also, he has therefore submitted that he may be permitted to withdraw the writ petition with liberty to file afresh with full particulars about the project and the act under which the plot of land has been acquired. So, in view of the above submission made by Mr. Rosid, this petition is dismissed on withdrawal, with the liberty to file afresh, right, with full particulars and governing act under which the plot of land has been acquired.
So including the necessary parties.
It is up to you. How can we advise?
Item 15.
Lordship, may the matter be taken after some time. My senior is on legs. Bless you.
Item 16.
Please, Lordship. Lordship, may I please humbly pray to take up the matter on Friday? My learned counsel is out of town.
Morning, you were saying something?
Yes.
What is it?
Similar matter has been listed with the identical facts and the exact.
Is there any order?
Yes, Your Lordship.
To us? The order previous to it?
I do not have it.
It was previous to it, it was order section 3887 2026. First order. NHIDCL? Who is the requiring authority? NHIDCL council is available. Miss R. Bora or Mr. C. Borua?
No.
You are NHIDCL. You are NHIDCL. No, NHIDCL. And Mr. Das also. Same thing.
Yes.
There were 4 earlier writ petitions.
Yes, Your Lordship.
In 2 cases, we have issued notices. But in 2 cases, we have asked to obtain the award stay, right? Okay. Heard Mr.
KG Chaudhary.
KG
Chaudhary.
Learned Counsel for the petition. Mr. Bora, you can. R. Bora. Learned Counsel for the petitioner, Ms. N. Bordula, Learned Standing Counsel, Revenue and Disaster Management Department for respondent number 1, Mr. N. Das, Learned Junior Government.
2, 3, 6.
Some for the respondent number 2, 3, and 6. Mr. D. Bora, Learned Counsel on behalf of Ms. R. Bora, Learned Standing Counsel, NHIDCL for the respondent number 4, and Ms. M. Das, Learned Standing Counsel, Public Works within bracket building department for the respondent number 5. Poster. The petitioner's main advance is that the structures stroke assets standing on a plot of land covered by tag number 102 under patta number 63 at Porgona, Pratapgarh, the Carbon district, which has been brought under the purview of the acquisition process under the provisions of the National Highways Act 1956, within bracket the NH Act for short, have not been assessed by the acquiring authority and the requiring authority. Full stop. The petitioner has stated that the structure stroke assets include a bungalow house, comma, a kacha house, includes a residential building, comma, boundary walls, a water supply system, a well ring, a bungalow house, a kacha house, and other structures. Close to. The petitioner stated that the petitioner is not aware whether the competent authority, comma, land acquisition, within bracket, corresponding number, three, has determined the compensation for the plot of land and the structure stroke assets, mentioned above, standing on the plot of land as per means of section 3Z within bracket 1 of the NH Act. First of para. Mr. Last line, some may paying for the response number 3. And Mr. Bora also paying for the when the other case, other cases,
One,
fixed on?
17th of August.
I've sought time till 17/8/2026 to apprise this court on the aforementioned aspects, including whether any determination is made under section 3Z within bracket 1 or not, comma, and if such a determination has been made to, comma, to place a copy of the award, so made. Two other cases are fixed already.
1708.
Get the award statement, that's all.
Item 17.
Yes.
So the petitioner is challenging the levy of the penalty in the instant case on the ground that the same is applicable without jurisdiction and contrary to the specific provisions of the
Levy,
levy of penalty below.
penalty.
Hello. Your lordship may kindly see the so-called notice was issued to me, my lord. And your lordship find at page 118.
118. 100. 100,
15 million,
100,
100 million,
6 perhaps.
106 million.
Huh.
And look, this was a notice issued in the lawsuit in the subject. Okay, please check. No, that the invoices were raised, but there was no supply of the goods. Now, you also may kindly see, I will take a loss with the relevant paragraph. At page 108.
Hmm.
While analyzing the details of the e-way bills, 4 patterns have been found which are as given below. 4 patterns have been discussed. You'll also may skip over the patterns below. And you'll also may kindly see the levy of the tax and penalty which has been proposed. Bottom below.
Can be treated as uneconomic supply or supply.
8, A below.
In tax, you should tell you has to find tax interest.
Yes. Yes.
25. And also may kindly come to the next page below. Interest levied in the section 51 is 12 crore something. And you'll also kindly mark it, next one. Penalty imposed under section 74(1). 21 crores. So in the so-called notice, the tax determined was 21 crores. And penalty under section 74(1) was 21 crores. Now, you'll also may see, I submitted a reply, and thereafter, the final adjudication order was passed. You'll also find. The file. So the tax cannot be levied if there was issue of the person without supply of goods or services, and this is an offense under section 122(1) and for this offense, only separate penalty is applicable. The provision has been clarified through the circular number so and so dated so and so 6 July 2017. This claim has been accepted as correct, and accordingly for pattern 2, where there was no involvement of the goods, means there was only movement of the invoice and passing of the ITC, and for pattern 4, where goods moved to a different destination direction other than what was actually recipient here, also supplied to someone else, and ITC benefit passed on to someone else without actual supply of the goods, separate proceedings will be initiated under section 122. Therefore, these 2 points are skipped from this demand order. This was accepted, and below you'll also see the bottom calculation below. Crores. It has been reduced to 1 crore. Penalty. The total came to 2 crore something. So earlier, my lord, the so-called was issued for 21 crores tax. After considering the reply, the demand has been reduced to 1 crore something, and on this, the interest and penalty has been imposed. This was issued to 122 for penalty, which was 214. Yes. Of the so-and-so, read with section so-and-so and so-and-so act. Now we'll also see, they start from where is a case. This is produced from the adjudication order. Exactly same. My lord, you'll also find. Okay. 200. My lord, also see. The so-called notice below of the adjudication order. Earlier one, 44 crores below. Now we'll also see page 236. Now, the final amount has been determined, calculated as under. Now we'll also see total so-and-so and total destination, the total amount. On the right hand side, you'll also find 20 crore, 22 lakhs. Crore something below. Out of that 1 crore, you'll also be seen the tax has been imposed. Okay. So after reducing that one, 20 crores, he's saying that the tax has been imposed, which was in the so-called notice, not the final adjudication order.
No, I'm not getting the point.
There are 21 crores you'll also be seen in the so-called notice. The tax was proposed. So-called notice is
21 crore 43 lakhs.
By law. Now, in the final adjudication order was also fine. The tax was imposed to 1 crore something. From reducing from 21 crore something this amount, it came to 20 crore something. Now he's taking. See the 20 crores. Now, the first part. Now the final amount has been calculated as under. Lots of what you and the penalty imposed under section 122(1), you'll also find 20 crores same amount. Section 122, Lord, of the AGST Act, Lord, the provision of levy of penalty, it is 100% of the tax evaded. Now, levy does not arise. Now, there was no levy of the tax in the adjudication order. For levy of the penalty only of tax only of 1 crore. 21 crore was proposed, my lord, earlier. But the reply of the petitioner was accepted. And thereafter 1 crore only the tax was levied. So there was no levy of 20 crores, which he is saying, of the tax at all. Now, if there was no levy of the tax at all, my lord, the question of evasion of the tax does not arise. Section, I take it also. The section, my lord, I think now it's this is
Okay.
very good.
We'll come at.
Well,
Yes.
well, I may summarize the facts which I placed before I take a lordship to the provisions of law, my lord. My lord, so-called notice was first issued, wherein the authority determined the tax at 21 crore something on the ground that the invoices were issued, but there was no supply of goods. Side by side, the authority also proposed the levy of interest and also penalty under section 74. The petitioner made submissions that there was a supply of the goods, but that was rejected. An alternate ground argument was made that if there was no supply of the goods, then the question of the levy of the tax under the GST Act does not arise at all, because GST is on supply of goods. Now, that argument was accepted, and after accepting the argument, the authority levied the tax only a portion of the goods where the supply was there, according to them, and that amounted to 1 crore something. And accordingly, the tax, interest, and penalty under section 74(9) was. Now, 122 penalty notice was issued to so-called notice below for imposition of the penalty, where the authority took the figures which were proposed in the so-called notice and issued the so-called notice. And in the final order imposing the penalty, the authority deducted the amount on which the tax was imposed, that is 1 crore something, from 21 crores, and balance was 20 crores. That was taken to be the tax. And under section 122, equivalent amount of penalty has been imposed. Now, I take a lordship to the provisions of law. My submission before lordship is 1 million, that the authority imposing the penalty cannot levy the tax. There is no question of levy of the tax by the authority. Levy of the tax is by the adjudicating authority at the time of passing of the order adjudication. Now, since the authority has said that no levy of tax is there, the question of the evasion of the tax does not arise, because first the charge, levy, quantification, payment, and if somebody has failed to pay or evaded, then the question of evasion will arise. So evasion presupposes the levy of tax. If there is no levy, the question of evasion of tax does not arise. Now, section 122, if your lordship looks into it, below.
Of AGST.
Well, CGST, AGST are the same provisions. There is no book on the AGST, below. Assam Goods and Service Tax. And it is also very difficult for the amendment to incorporate and all those things. You also see section 122, below. And you also got it, below. This says, below, penalty for certain offenses where a taxable person who also may come to 2 million issues any invoice or bill without supply of the goods or services or both in violation of the provisions of the Act and rules made thereunder. Now, if somebody has done this, below, then you'll also may see after 21 below. Lordship got it below. After 21.
Yes.
He shall be liable to pay a penalty of 10,000 rupees or an amount equivalent to the tax evaded. Now, whichever is higher, the bottom below. The other conditions are there which are not applicable. So the penalty will be 10,000 rupees or equivalent to the tax evaded, whichever is higher. Now, in my case, since there was no levy of tax at all, the question of the evasion of the same does not arise, and thereby the authority below went absolutely without jurisdiction contained the provisions of the Act in levying the penalty on an amount which is not tax at all. Now, this is my first submission for Lordship. I will also may further skip over and come to Milord section 127. This is a restriction on imposition of the penalty, Milord. Section 127. Here it is, Milord. Power to impose penalty in certain cases where the proper officer is of the view that a person is liable to a penalty and the same is not covered under any proceedings under section so-and-so, which includes section 74 and 74A of the he may issue an order levying such penalty after giving you a reasonable opportunity of being heard. So a proper officer can impose a penalty other than a case where the penalty is covered in a proceeding under section so-and-so of the Act.
And same is not covered under section 74.
Below the penalty is covered, I will plus you. You also see the so-called notice. The
First one or second one?
First adjudication order. So-called notice below.
Page 106.
106 below. Annexure 6.
Annexure 6.
My lord.
Annexure 6. Summary of so-called notice.
My lord. And you also will find at page 100, page 114 below.
Under forward charge.
So tax, interest, and penalty imposed under section 74(1).
Taxable value declared mentioned fine so can be treated as.
That was on the entire amount below. Now we'll also may kindly once again look at section 127 below. It doesn't say below where penalty has been imposed under section 74, 74A. it says, my lord, where penalty is covered under any proceedings under section so and so of the act,
Is not covered.
is not covered. Meaning, my lord, if it is covered, then penalty cannot be imposed. If it is not covered, penalty can be imposed by the authority under 122. But if it is covered in any proceeding under section 74, 74A, whatever is there, the penalty cannot be imposed. Now, the question arises, what is the proceeding? Because it says, my lord, covered by any proceeding.
But the purpose officer is of the view that a person is liable to a penalty. The same is not covered under any proceeding. Under section 74 may issue an order having such penalty. After giving a reason of virtue of part to such. Two conditions.
My lord.
One is that where the proper officer is of the view that a person is liable to a penalty.
My lord.
This is one.
One.
And the same is, second condition, the same is not covered under any proceeding under section 74. Let us take the example.
My lord.
He may issue an order levying such penalty.
After giving a reasonable opportunity of being heard.
Yes.
So first the authority will conclude, my lord, that penalty is leviable. Then he will verify that whether it is covered in any proceeding under section so and so of the act. If it is not covered, he can impose the penalty.
In the adjudication order,
No, adjudication order, the penalty has not been imposed on the entire amount.
he says, page 205,
My lord. My lord, 205, my lord.
the claim has been accepted as correct, and accordingly for pattern 2, where there was no movement of goods,
My lord.
means there was only movement of invoice and passing of ITC. And for pattern 2, where goods moved to different direction other than that of the actual recipient. Here also goods supplied to someone else and ITC benefit passed on to someone else without actual supply. Separate proceeding will be initiated under section 122. Therefore, these 2 points are skipped from this demand order. So, what does it mean? That he is saying that it is not covered under section 74?
Well, he is saying, Lord, that on other than those 2 transactions, the tax will be levied. Those 2 transactions, the tax cannot be levied because there was no supply of the goods. Now, accordingly, my lord, he has levied the tax only on one transaction, whatever one pattern is there.
Pattern 2 say no movement of goods.
My lord. On that, he has levied the tax and interest and penalty. That is 1 crore something tax, and balance is, my lord, the tax and interest and penalty. Now, the question which arises for consideration for loss is that, my lord, the language which has been used in section 127 is covered under any proceedings under section 74. What is the meaning of the word proceeding?
It says not covered.
It's not covered, my lord. Not covered. If it is covered, my lord, he cannot levy a penalty. If it is covered, the authority cannot levy the penalty. If it is not covered, he can levy the penalty. Now, in this case, my lord,
yes,
the penalty was there in the so cause notice. Proposed, my lord. There is no dispute about that fact. Now, you lost him. Can you see what the meaning of the word proceeding under the GST Act? My lord, a compilation I have given, my lord.
Definition is there.
My lord, there is no
Definition.
definition that Supreme Court has defined, my lord. One minute, please. at page 92. Page 163. It starts with page 92. At 11 part, you'll also find at page 163.
Yes.
Para 63. Near the end. We may now proceed to elaborate on our understanding of initiation of the proceeding within the meaning of so-and-so of the Act. In so-and-so sixth edition, that is so-and-so defines proceeding as under. It is not a technical expression with defined meaning attached to it, but on one ambit of whose meaning will be governed by the statute. The word proceeding will be given a narrow or wide meaning, import, depending upon the nature and scope of the enactment in which it is used and the particular context in the language of the enactment which it appears. Thereafter, my lord, para 64. We may quote the extract from the Black's Law Dictionary at page so-and-so as under. An act which is done by an authority or direction of the court, express or implied, an act necessary to be done in order to attain a given end, a prescribed mode of the carrying on effect of a legal right. A so-called notice, my lord, also page 65, para 65. A so-called notice is a document served on the noticee requiring them to explain why a particular action should not be initiated against them under the GST regime. Issuance of so-called notice is a mandatory provision, precondition for raising a demand. It forms the bedrock for proceedings related to the recovery of tax, interest, and penalty. The notice ensures adherence to the principles of natural justice by granting the SSC an opportunity to the present their case before any adverse action is taken. In a sense, it serves as both a procedural safeguard and a legal necessity, marking the commencement of the quasi-judicial adjudication under the Act. A so-called notice sets in law the motion concerning the liability under the statute containing charges that a specific person is called upon to answer. In other words, it sets out the alleged violation of the legal provisions and requires the SSC to explain why the duty shall not be recovered from thus. Thus, a so-called notice cannot be vague, nor can be any allegations be made without evidence being commensurate with the gravity of the charges leveled against the noticee. It sets forth the framework of a proceeding proposed to be undertaken and provides the noticee with an opportunity to submit their explanation before the adjudicating authority. It outlines the background of the initiation of such proceedings, whether arising from an audit by account of by the internal audit with scrutiny of returns or intelligence gathered by the officers by the Audit and Intelligence Department. It is further mandated that authority issuing the notice must particularly set out all relevant legal provisions under which the alleged contraventions are framed. The materials obtained through summons and relied upon by during the so-called notice must be appended and disclosed to the SSC. In a sense, a so-called notice enumerates the charges leveled against the SSC. Thereafter, my lord, you also may skip over. May come to my lord. Para 72, my lord.
Yes.
The statutory framework of the CGST Act does not admit of any interpolation of the phrase initiation of the proceedings. Under section 6.2 so and so, other than the one which lies to the issuance of so-called notice, an action other than the one which Site to showing issue election qualifies as proceedings only when it is undertaken with the object of attaining a determined outcome. In the present case, the issuance of the so-called notice partakes the character of proceeding that is inherently required to culminate in a definite determination. There must exist a point of finality and conclusion thereto. So, my lord, the Supreme Court has observed,
Can we come to page 270?
page 278, my lord,
270?
of the same judgment, my lord,
No, this brief.
my lord. My lord.
There are 4 rows
My lord,
at page 270.
270, my lord.
No RFID record found. Total number of UA bills 785.
My lord,
Taxable value, then breakup, then 18 crore something.
my lord,
Then other destination. Total
Right.
number of UA bills 67. Taxable value 61 lakh something. That is 1 crore 72 lakh.
my lord.
That comes to 20 crore 22 lakh 79,191.
My lord,
This is some total, right?
my lord,
And equivalent penalty, I think.
my lord.
Meaning the total is 44 crore.
Here it is 40 crores. No, but here it is 20 crores only.
40 crore.
The 40 is there, but he's imposing the penalty only. He's not imposing the tax.
He is not imposing the tax.
No. This is your order under section 122. Proposed notice under 122.
Sir, reply no, sir, seeking a clear to your order. Nothing to say. Demand, the details of demand. He said the details of demand
My lord,
is under.
my lord, what he has done, just to reiterate, my lord, again once again. My lord, because the tax penalty can be imposed according to the equivalent of the tax evaded. So now he is determining that what is the amount of tax evaded. Now, which figure he has taken from the adjudication order. Suppose out of the
Okay, we want to say that that adjudication
my
order
lord,
did not determine tax evaded.
my lord, that was no tax.
It got dropped.
My lord,
It got dropped,
my lord,
right?
my lord,
So he has picked up that figure
my lord.
and imposed this penalty.
Penalty.
So
Because
there
yes,
is no independent adjudication
of the tax amount.
of the tax amount.
Well, because you're asking me just seen, earlier it was 21 crore something.
Yes.
Out of that, he imposed the tax
Pattern 2 and pattern 3 got dropped.
drop. So he imposed the tax of 1 crore something, philosophy in education. Now, if it is deducted from the 21 crores, it comes to this figure.
So the earlier adjudicating authority simply dropped that figure.
No tax.
Drop that figure, pattern 2 or 3.
My lord.
So then he picked up the figure, but there is no adjudication that this is to be levied. This amount, there is no independent application
Well, it is
of mine on his part.
no, well,
Second time.
Lord, he cannot apply his mind. Lord, you're asking just seen, Lord. He, so far as tax part is concerned, he cannot determine. Tax part only can be determined by the adjudicating authority, who will determine whether any tax evaded was there or not. Now, if there was a tax evaded, then he will proceed under section 122 and calculate the penalty. Under this, my lord, you'll also find the first 2 clause, my lord, that supply of the goods, without supply of the goods, invoices are there. That's all. Thereafter, he says 10,000 rupees or 100% of the tax evaded. Nowhere in the section 122, it is provided that he will determine the tax evaded. That is not within the purview of section 122. Now, adjudicating authority has come to the conclusion that since supply was not there, and thereby tax cannot be levied. Now, if the tax cannot be levied, and which has not been levied, the question of the imposition of the penalty on the figures from the so-called notice does not arise. He has reproduced everything, whatever is a line to line, from the adjudication order. From the very beginning to the last, it from the adjudication order. Secondly, my lord, as I submitted for lordship, lord, again, even for the sake of repetition, my lord. The second argument which I am advancing before your lordship, lord, there was no dispute that 21 crore something was proposed as penalty under section 74 in the so-called notice in the under section 74 of the Act. Now, this penalty is covered under any proceeding under section 74 of the Act. The legislature has not used the phraseology that penalty has been levied under section 74. If the words would have been there, my lord, that the penalty has been levied, the legislature has not used that phraseology. It says it is not covered in any proceeding. So covered in any proceeding and levy and imposition of the penalty are altogether different things. If it is covered in any proceedings, then the proper officer has no power to impose the penalty. Assuming, my lord, in the instant case, it was covered in the proceeding under so-called notice. Finally, it was dropped because there was no evasion of tax. Now, since it was covered in the proceeding, the result of that proceeding, it doesn't matter. Section 127 nowhere speaks that ultimate result of the proceedings. If it is covered by the proceedings, the other provisions of the penalty are out. Otherwise, one of the legislature would have used that where penalty has been imposed under section so and so of the Act. Very deliberately, the words of which have been used are that covered in any proceedings under the so and so. Levy and imposition are altogether different things, than covered by any proceedings. Now, in this case, there is no dispute that in the so-called notice, this penalty was covered.
No, so-called notice, Justice Partivala has explained. But ultimate the decision is the demand order, the first one.
Well, the
If I can,
the question only that, I'm sorry.
no, I'm not getting your point.
Well, I'm, once again,
So-called notice, he has raised certain that as to why this should not be imposed upon.
penalty also.
Penalty also, right? Liability determined under forward charge. Page 144. There he says something double trip, then another destination. This pattern 2, 3, and 4. Right. Then total is 21 crore 43 lakh something.
Absolutely.
Then it an interest amount to be levied under section 51. Then penalty to be imposed under section 74(1).
That is an equivalent amount.
Right. Equivalent amount to the total amount. Right. So final amount, total amount is 44 crore something. So basically it is 21 crore 43 lakh. Right. So ultimately when he
Pass the order.
pass the order.
One
Pass
point.
the order. Out of the 3 pattern, he dropped 2.
My lord,
Drop 2. Right?
my lord.
Drop 2, pattern 2 and 4, but he retained pattern 3.
My lord.
And he said that
Penalty
pattern
will be-
2 is no movement of goods.
My lord.
There was only movement of invoice and passing of ITC.
My lord.
1.
My lord.
And secondly, pattern 4, where goods move to different direction other than that of the actual recipient. And these are to be separate proceeding
Under
for under section 22.
Right.
Right. Therefore, these 2 points are skipped from this demand order. This is what he has observed. Then other part he has rejected, and pattern 2 and pattern 4 are skipped here to initiate separate proceeding under section 122. So far, so good. Then that so-called notice has been issued.
My lord.
I think that is on
Is
page 214
my lord.
under section 122
My-
1. Right.
My lord.
Now, just tell me in simple terms, what is wrong with it?
Just below the authority, while imposing this, giving the so-called notice of the penalty, has taken the figures of the tax which was there in the so-called notice and which has not been imposed.
Okay.
Now, if the tax had not been imposed or levied, the authority is not determining the tax. He has no power to determine the tax. Under
So that that authority who has initiated the proceeding under section 122
Right.
has no authority to determine the tax.
That you'll also see the provisions also.
Under section 122, 1 subclause 2
Right.
and section 127.
Right.
That is your case.
First, know that he has no power to determine the tax. And once the tax had been found that there is no tax at all by the authority, then he cannot issue a so-called notice on the basis of the figures which were there in the so-called notice.
So basically, there is no existence of jurisdictional fact
My lord.
for the executing authority to issue the so-called notice under section 122(1). Sum and substance, that is your case.
First, because he cannot take the figure, will not impose himself the tax. And that he has also not done it because he has taken only the from the order, whatever was there, the same has been reproduced.
Okay.
You'll also see the last part also in the so-called notice. He has simply given the calculation. No reasons that why penalty should be imposed. Nothing. Nothing is there. He has calculated, and that's all. There is not a single whisper, because penalty being a classic criminal proceedings, my lord, the authority has to apply its independent mind. Now, second, which so I was submitting to Lordship, my lord, that the authority committed a manifest error of law while imposing a penalty, taking the figures as tax evaded, whereas there is no tax levied at all by the authority. And once there is no tax levied, the question of the tax evaded does not arise. And thereby these figures of 20 crores or something does not exist after the filing of the final order, passing of the final order. So he could not have imposed the 100% equivalent amount of tax evaded. Where from he has found the tax evaded? Second point, which was I raised before Lordship, that again repetition, although I have submitted for Lordship, that section 127 puts a bar on imposition of the penalty in the positive way. If I say, it says that you can impose a penalty if it is not covered under any of the proceedings of 74. Proceedings, the Supreme Court has said that proceedings is from initiation of so-called notice. Now, this penalty of 21 crores, whatever was there earlier, was a subject matter of the so-called notice. It is covered in the proceedings under section 74. If it is covered under section 74, in the proceeding under section 74, the power of imposition of the penalty does not arise, section 127. Because section 127 is not speaking that where the penalty has been imposed or has not been imposed, it doesn't say. It only says where a penalty is covered in any of the proceedings. Admittedly, in the present case, the penalty was covered in the proceedings under section 74 by issuing so-called notice, which the apex code has said the proceedings under the act means initiation from the issuance of the so-called notice. So the distinction between the words, imposition of the penalty and covered in any proceedings. So in my humble submission, the matter being covered in the proceeding 74, section 120.
Yes, Mr. Chaudhary.
Lordship, at this stage, notice me go, Lordship, because I have to take instruction as to why they have given same facts as given in the educating order in the so cause.
What Dr. Ishara Planning Council, Senior Council, is stated by Mr. A. Kaushal, Planning Council for the petition. Mr. B. Chaudhary, Standing
Well,
Council,
there are other points which I am not urging at this stage because there are
Finance and Taxation Department, Government of Assam, for the response number 1 to 4. And Mr. V.K. Chopra, Central Government Council, for the response number 5. First of Farah. The petitioner was initially served with a so-called notice under section 74 of the Assam GST stroke Central GST Act 2017. RW section 20 IGST Act and section 11 on (13/3/2025). Posted by the state super notice, the petitioner was asked to show cause as to why tax amounting to interior was asked to show cause interior as to why tax amounting to rupees 21 crore 43 lakh 69,099 and penalty of equivalent amount under section 74(1) should not be imposed upon it. Full stop. Subsequent to the reply submitted by the petitioner, an order came to be passed on 19/2025, limiting the amount of tax to 1 crore 17 lakh 3,171.20, which a similar amount with imposition of similar amount as penalty under section 74 within bracket 9 post of. In the said demand order, comma, the other amount sought to be other amount out of is 21 443 lakh 69,000 99.09, huh? Along with the penalty sought to be imposed, came to be dropped with an observation that for the said amount, their separate proceeding would be initiated under section 122. Post of. Immediately thereafter, a show cause notice under section 122 within bracket 1 came to be issued by the on 19/2000 on same day, meaning they were same day.
Same day.
On the same day, huh? Immediately thereafter. That is on 19/2025. A show cause notice under section 122 1 came to be issued not on the same day, perhaps. Thereafter, on 3/12/2025, a demand notice under section, is it correct?
That page 214. Dated, you know, 9/10/2025.
Okay, same date, same date.
Lordship find after the subject.
And it ends at which page?
Well, it ends at page
214, show cause notice ends at
236 now. Of the text.
So from the text and tenor of this show cause notice,
My lord.
it transpires that he has reached the final view.
What he has done, you know, he has taken from the.
That I have understood.
And just simply given the calculation, final calculation.
A final calculation.
My lord.
And there is nothing as to
Why penalty should be
asking
imposed? No, nothing.
show cause as to why this should not be
My lord,
He has almost determined
my
picking up that from the demand order.
demand, my lord, the so-called order.
Picking up that from the demand order.
Demand order. Exactly cut paste.
But in the last line, lordship only, he has been asked to give a reply.
What reply I will give, you have determined.
On 9/12, no, 9/12, no, 9/12. A show cause notice under section 122 within bracket 1 came to be issued. Giving the final amount. As rupees 20 crore 22 lakh 79,191, page 136, 236. Towards tax and an equivalent amount towards penalty under section 122 within bracket 1, asking the petitioner to submit his reply within 30 days from the receipt of the said notice. Post up. The petitioner submitted a reply to the said show cause notice.
In this penalty so-called notice, there was no reply.
Or not reply.
Because, my lord, I have explained in the petition, my lord, that the documents were supplied to me on 18/11.
Okay.
18, my lord. And I requested the 30-day time from that was given. That was not given, so I not.
Okay. Thereafter. On which date? 3/12/2025.
My lord,
Okay. The order
3/12/2025.
of imposition of penalty came to be passed, imposing
At 269.
making a demand for rupees 20 crore 22 lakh 79,191.90 towards tax with an equivalent amount with imposition of equivalent amount towards penalty under section 122 within bracket 1. Post up.
Lord, I filed a rectification petition against this order.
Okay.
That was also dismissed. So I have annexed in the petition.
A rectification application submitted by the petitioner against the order dated 9/3/12/2025 on 2/1/2026 came to be rejected on 26/6/2026. Correct? Post up. Assigning primarily the show cause notice issued under section 122. We should dated 9/10/2025 issued under section 122 1 and consequential demand or order imposing penalty dated 3/12/2025. The present requisition has been preferred.
Also the rectification order.
As well as the order of rejection of the rectification application. The present rectification has been preferred. So, Mr. Dr. Saraf, the senior counsel preparing for the petition, has contended that for issuance of the impugn so cause notice and the order of imposition of penalty, the condition precedents are required as per the provisions of section 74, section 122, within bracket 1, within bracket small Roman 1, and section 127, were absent. Full stop. The adjudicating authority did not levy
Right.
the tax for the did not levy tax amounting to rupees 20 crore 22 lakh 79,191.90, and therefore what does it call? He is also proper officer.
He's also for prohibition.
Therefore, the proper officer who issued the demand show cause notice under section 122, under section 122(1) could not have the power, authority, and jurisdiction to pass such order of imposing penalty. Mr. Chaudhary, learned standing counsel, Finance and Taxation Department, appearing for the
127 submission also, one line below.
I do not require 127. One is 74, one is 122, 1 Roman 2,
My lord,
and section 127.
my lord, my lord.
Mr. Appearing for the respondent 124 has submitted that he needs some time to respond to the contentions advanced by the petitioner in this
Union of
situation.
India is also part.
He's there. He's there.
My lord.
Issue notice written evidence also. As Mr. Chaudhary 124 and Mr. Chopra CGC for the respondent 5, no formal notice, extra copies of the petition within 2 working days, having regard to the provision made in this petition and considering the provisions contained, including Nathan perusal of the and considering the manner in which the show cause notice under section 122(1) dated so and so, and the order imposing penalty dated so and so came to be passed. The provisions contained in section 74, 122(1)(2) and section 127, this court is of the considered view that the petition has been able to make out a prima facie case for an interim order. Accordingly, it is observed in an interim that there shall not be any coercive steps against the petitioner in terms of the show cause notice dated so and so, on the basis of the show cause notice dated so and the order imposing penalty dated 3/12/2025 till the return.
My name may be.
Name of Mr. B.K. Chopra, learned Central Government Council, is to be reflected in the respondent side in the corpus.
14 September.
For the respondent one. You want to have this back?
So can you keep in the file?
Okay.
1409.
You always a pleasure to ask you for this.
No, I am trying to comprehend what are the provisions. These are the provisions. Those are new to me today.
You always a pleasure.
Item 18.
Yes, Mr. Bora.
Freezing of bank account without any notice, without
And
anything.
Mr. B.P. Boral, learned counsel for the petitioner. Yes, Mr. Sharma,
Your Lordship.
you are for the bank.
Yes, Your Lordship.
Okay, political and us, learned junior government advocate for the respondent number 1, and Mr. M. Sharma, learned counsel for the respondent number 2 and 3. We need not have to issue notice to Reserve Bank of India for
Yes,
this.
only.
Okay. The petitioner has stated that he has been maintaining a savings bank account number so and so with the respondent number 3.
This one, not really.
Full stop. The case of the petition is that in June 2026, the petitioner came to learn that the respondent bank authorities have blocked the said bank account without any prior notice and without any information, without intimating the region for which the bank account has been blocked. So submission notice returnable on so and so. As Mr. Das 1, Sharma 2 and 3, no formal notice, extra copies. Mr. Sharma, learned counsel appearing for respondent 2 and 3 shall file, shall obtain instruction as regards the region for keeping the bank account of the petitioner blocked, and if due to any suspicious transaction stroke credit in the bank account of the petitioner, if the reason is for any suspicious, if the reason for keeping the bank account of the petitioner blocked due to any suspicious transaction, stroke, credit, and stroke or any complaint, stroke cyber complaint, then the details about comma their details. First of such instructions are to be placed by way of an affidavit on or before the return.
14 September, 1409. 19.
Since 1981, my lord, the land is under their possession. Several times, court has allowed them to acquire, but they failed, my lord, notification, my lord, lapsed. Now they have acquired it, but no payment has been made. They have, it appears, my lord, from the letter that they have fixed it 4 crore 10 lakhs. My
Which
lord,
one?
That is, my lord, yes, your lordship will find it, page 57.
Firstly, how much of your land? Area?
3 kathas 13 lisa. And my lord, the requisition compensation is to be paid, my lord, rental compensation. That was the direction by this honorable court.
Which is the where is the direction?
My lord, yes, your lordship will see, my lord, the operative portion, my lord, at page 62, the judgment is from beginning, my lord, at page 50 onwards, but operative portion page 22, page 62, para 22 onwards.
Now, in this petition, what determine make payment of the area rental dues.
Yes, area rental. And the rental, my lord, whatever they have paid, that will be adjusted. So how they fixed that also I don't know, but they have fixed it 4 crore 10 lakhs. We want at least, my lord, I'm suffering, my lord. So at least that could be paid.
Art Mr. G. N. Sarawalan and its senior counsel, stated by Miss aforesaid and counsel for the petitioners. Mr. Miss N. Bordolo, and standing counsel, Revenue Department for the respondent number 1 and 2. Mr. D. P. Bora, Standing Council, Health and Family Welfare Department for the respondent number 3 and 4.
3 and 4.
And Mr. N. Das, Senior Government Advocate Assam for the respondent number 5 and 6. Post of the subject matter of this petition is a plot of land measuring 3 kathas.
10 less.
15 or 10?
My lord,
I don't know, 15 or 10?
10. 13. 3 kathas, 13 liter.
Huh?
13 liter. 13 liter.
3 kathas?
13 liter.
13 lessons.
But they constructed the building.
Which came under requisition under the provisions of the Assam Land within bracket Requisition and Acquisition Act 1964 as per back as in the year 1981. Full stop. In a proceeding, in a writ proceeding, in a writ petition. Oh, no, when the petitioner preferred a writ petition, WBC number 1816/2013. The writ petition came to be disposed of by an order dated 15/6/2023, observing inter alia that within bracket 1, the appropriate authority in the state government would be at liberty to initiate fresh acquisition process or to take any other action that would be available in accordance with law within an outer period of 4 months from the date of service of a copy of the said order, failing which the land would become entitled to be restored back in the name of the petitioners in the records of right. And 2, till such time press notification was issued, the petitioner should be entitled to rental compensation. Then what happened?
Then again, my lord, they have issued a notification, but that was also left.
Okay. It is a case of the petitioner that as on date, no valid land acquisition process.
No, now they have a
Which one?
This is, my lord, it is now that your lordship will find, my lord, at page 65. This is the value.
65.
After granting several times, my lord.
It is the case of the petitions that an order under section 3(1) of the 1964 Act was issued on 14/8/2024. However, the proceeding initiated by the said order dated 14/8/2024 has not been brought to its logical conclusion till date. Neither the rental amount has been paid to the petitioner. Mister, you are in serious trouble.
My lord, that acquisition proceeding has been initiated by the district commissioner, my lord.
Who holds the purse? You. Yes, Mr. Das. Huh? You file without fail. Your response. Issue notice returnable video. As Mr. So-and-so appeared accepted. No formal notice, extra copies. As the subject matter of the writ petition is traceable to the year 1981, the respondents shall ensure that their counters are filed, without fail, on or before the returnable date.
11 September, 1109.
Apart from compensation, heavy penalty.
Already interest is there.
Plus, there is called penal interest. Apart from interest, there is penal interest.
Over 1 week.
Huh?
Over 1 month, my lord has been got.
1 month is granted.
1 month. 16/9.
Normally, we see that section 3 order is passed today. Section 6 order is passed next day. Is it not? We have seen.
We have filed depends.
When you require the land very urgently, but
They have already
since you are
contacted-
sitting over the land by establishing medical college, so there is no hurry on your part. But when you start any project in and around airport, section 3 order passed today, section 4 order is passed next day. So why 1 month?
Obligement.
Item 20.
Extra copy, yes, definitely. Yes.
Well, this is a transfer, not a civil bench 5.
Nothing service here. No, prayer can be disguised. Posting of respondent number 7. Who is he? Assistant Director of Agriculture. Why should we interfere in bench 4? This court is not having any roster with regard to transfer. Mr. K. Miral and counsel for the petitioner. And Mr. Who is for agriculture? Anybody from agriculture? Because who is the employer of respondent number 7? And the land counsel for the respondents. State respondents have submitted that the subject matter of the petition would pertain to bench strict so registry to verify the subject matter and thereafter release the case before appropriate. We are not recording any names.
Item 21.
Yes.
Lordship, the petitioner maintaining a saving bank accounts of SBI at Ramakrishna Nagar branch in the district of Simuvi. But suddenly it was kept on hold. On inquiry with the bank authority told it was held by the head office of the SBI due to some fraudulent transaction.
Yes, what is a fraudulent transaction?
But when the petitioner asked to furnish the details of fraudulent transaction, they have failed to furnish the same. They have
Pardon,
furnished a bank
Mr.
statement. Jayuddin.
J.
Uddin.
Uddin. Learned counsel for the petitioner. You are for?
I am for the respondent 3 and 4.
Okay.
Union of India.
Okay, Central Government Council. Okay, Mr.
SK Dekka.
SK Dekka, learning Central Government Council for the respondent number 3 and 4. Post of. The petitioner stated that he has been maintaining a savings bank account number so and so at Ramkrishna Nagar branch, Sribhumi of the respondent State Bank of India. Respondent of type. It is the case of the petitioner that without any prior notice and without disclosing the region, any region, the respondent authorities, more particularly the respondent number 5, has blocked the said bank account of the petitioner. To stop ongoing inquiry, the petitioner has been informed that the instruction to block the account has been placed on receipt of a complaint, registration of a complaint with the respondent number 4. Issue notice, returnable on students. But I go to the M. Sharma, M. Sharma Nalaga, the respondent State Bank of India authority. I go to that item of number 18.
18.
Same tips, for DECA 3 and 4 extra copies, steps upon respondent number 1, 2, and 5 by speed post.
14 September, 1409.
Much obliged, Lordship.
Item 22.
For a moment, kindly have a look at plus 30.
Page
30.
30.
Yes, sir. Paragraph number 8.
Seeing that is already taking up the grievance of the petitioner.
After this order, Your Lordship,
Councilors places the accident. This is what? For what?
for
A direction to grant compensation to the petitioner under Assam Victim Compensation Scheme. So and so. Husband of the petitioner expired in a road accident. The offending driver and vehicle has remained untraced so far. Under such circumstances, DLS. Okay. Then the court directed that DLS will look into the grievances and pass appropriate order.
But
Then,
it has been not passed.
yes, there is already a direction.
I'll obtain instruction. ma'am.
You
I
can
will
obtain instruction. Okay. Then we proceed up next week. Heard Mr. S.I. Akan, learned counsel for the petitioner. Miss M. Bormal, learned junior government advocate Assam for the respondent number 1 and 3, and Miss R. A. Chaudhary, learned standing counsel ASLSA for the respondent number 2. Para. In an earlier petition referred by the petition, WBC number 6043/2024. This court passed an order on 27/11/2024, directing the respondent number 3 to look into the grievances of the petitioner and to pass appropriate thereon. Full stop. Stating that despite elapse of more than 1 year and 1.5 years, no order has been passed by respondent number 3 in the application filed by the petitioner seeking grant of compensation under the Assam Victim Compensation Scheme from 2012. Full stop. Hence the petition. Ms. Borman and so has submitted that she'll make endeavor to obtain up-to-date instruction in a matter from the respondent number
Three.
3 and has sought for listing of the case after 1 week. List the case on students.
21st August, 2108. Item 23.
May I please your lordship? My lord, this application is filed for issuance of direction to the respondent number 2 and 3 for release the compensation that was given by the respondent number 1 in rupees 5 lakhs, my lord, under the victims compensation, my lord.
Come to page.
Your lordship kindly seek annexure 1 copy of the judgment and order dated 28/7/20
Yeah, aforesaid amount.
is from 9
We
page number.
direct the child of the accused revised. Twenty-two. 87. That judgment was delivered on 28/7/2022.
Yes, my lord.
Then what happened?
My lord, the amount was paid by the district legal service authority, my lord. And when the payment was given, my lord, there from the district legal service authority, there was a
18/8. It's in register.
direction was goes to the respondent number 3, branch manager SBI, Zorabad branch, to fix the amount rupees 5 lakhs for 5 years, my lord, in favor of the petitioner, my lord. And
Yes, madam.
and the
Madam,
yes, my lord.
come to page 9.
Yes, my lord.
Last line, date of hearing and judgment. Right?
Yeah.
28/7/2022.
Yes.
Right?
Yes.
Then come to page 28. Para 40.
Para 40.
The amount shall be
Yes.
kept in a fixed deposit with the said scheduled bank for a period of 5 years in the name of the child.
Yes, my lord.
So, 5 years,
My lord,
I
5
am
years.
not elapsed.
Yes, no, my lord.
I cannot perhaps interpret or somehow relax the condition imposed by the division bench. I cannot do it. Is it not? 5 years. So, July 28 July 2022, meaning thereby
Yes, my lord.
28 July 2027.
27.
That's whatever the division bench has observed, 5 years. I cannot modify that order. You have to seek
Wait for the time.
modification of the order. Seeing that I have now become major, please modify that order. For me, it is not possible.
Yes, my lord.
What do you say?
Yes, my lord.
Otherwise, I could have revised all the orders of the division bench. Is it not?
Yes, my lord. So your
There will be havoc then. All the single benches will revise the orders of the division bench. No, no, this is not the order. It should have been this. 5 single benches every day to revise larger benches order. Not possible. You are legal aid counsel.
yes, my lord.
Respondent
legal.
number one is also not properly
Ah.
addressed. Respondent number one.
Respondent
Take a
number
call. I cannot.
my grievance is only for respondent number 2 and 3, my lord.
We cannot interpret and modify or vacate the order of the division bench. Get the matter agitated before division bench, criminal bench, that I have become major. I need the money, though 5 years have not elapsed. Please modify that order. Take a review and modify. Not possible.
So your lordship kindly send the matter for
I cannot
division bench
send.
placed before
Madam,
division bench.
if it is possible for me to send the matter to a division bench, I could have sent it. Division bench can send the matter to the single bench. Single bench cannot send. It is you as a legal aid counsel has preferred this without looking into this 5 years period. Had Miss BRA Sultan Al legal aid counsel appearing for the petition. Yes, madam, what do you say?
She may file appropriate application before the division bench, ma'am. I would like to suggest it.
And Miss M. Borman, learned junior government advocate,
And I may
respond
prefer
number
in
1
the-
and 2. 1 and 2,
2 and 3.
whatever.
Only 2, my.
Mr. 2. Miss Sultan Al legal aid counsel has submitted that from the period fixed by the division bench in its judgment and order dated 28/7/2022. The petitioner would be required to approach the division bench for modification of the or relaxation, modification stroke relaxation of the period of 5 years, and therefore she may be allowed to withdraw this writ petition with the liberty to approach the division bench, with liberty to approach the division bench in view of the submission made by Ms. Sultan as legal aid counsel for the petition. This petition is dismissed or neutral, with the liberty as sought for.
No, so bless.
Item 24.
Was going to be case, Lordship. I may be allowed to file in this case an additional affidavit, some necessary document left out, Lordship, which is.
Why you are always in a hurry? Huh? Don't enclose this required document when you file the petition first. Then fill up all the on the request of Mr. ABT Hogg, learned counsel for the petition that is passed over for the day. Miss M.D. Bora, learned standing counsel,
Cooperation department.
and Miss M. Borman, learned junior government advocate for the official respondents are in attendance.
25.
This is regarding for a compensation of the land and the Jirath amount, my lord, not properly assessed.
not properly
Assessed.
assessed.
That's why you have already,
This is under what? Direct purchase. Direct purchase
yes, directly.
by way of negotiated settlement. Now, what is the order? Your land is sought to be acquired or what?
Yes, already acquired, my lord.
Huh?
But payment made.
Cannot be. Where is the notice? Assam gazette's
Lecture one,
the
my lord.
acquisition of land for. You have objected.
Yes, I've received an amount, my lord, but
Huh?
I've also received some amount, my lord.
Where is that mentioned?
That is kindly page, annexure 2, page 14, kindly see a notice, my lord. As per this notice, we have submitted the records and accordingly we have received, I have stated in the para, my lord.
Mr. Chaudhary,
Yes,
in this notice, it is clearly mentioned in the last paragraph
yes, my lord.
that if any objection is raised
Yes,
by concerned landowners, the same may also be brought to the notice of the district level land purchase committee within a period of 30 days. So did you raise any
yes,
complaint, objection? 30 days,
yes, my lord.
30 days. Where is that?
Para 4, my lord, page number 6. I have stated.
Where is your annexure?
Annexure is, annexure 4, my lord.
That is of 30/12/2023 after 1.5 years.
My lord, after receiving the amount, I have objected.
That is the problem.
But the when amount is not
Ah,
not sufficient, my lord,
Mm.
not appropriate amount, my lord. Miserably, the less amount I have received.
that is what the direct purchase scheme is by negotiated settlement. There has to be an agreement. You must have executed the agreement.
Yes, my lord.
Is it not?
But I have.
Otherwise, if you do not agree, then they are required to acquire the land by the following the provisions of 2013 Act. But it is a case that by negotiation they will settle them. Then you have to execute the agreement. Thereafter, after receiving the agreement, now you will become a crybaby after 1.5 years.
My lord, I have been instructed by them, my lord, to submit a representation. They will see, my lord.
Issue notice at this stage. Have you gone through the provisions of the notification, which they mentioned that 20,
Within 30 days to.
no, notification dated, government notification, which is mentioned in first paragraph of page 14.
My lord.
20/01/2000, not 20, I think. 2012. Because I know, because that day I dictated. Assam Gazette. No, so. Direct purchase. Heard Mr. A.Y. Chaudhary, Land Counsel for the petition. PWD-RD, M. Das Land Standing Council, PWRD. For the respondent number 1, Mr. A. Aforesaid. Okay, respondent 1 and 3. And 6 also. Mr. A. Aforesaid, Land Standing Council, Revenue Department for respondent number 2. And Miss M. Borman, Land Junior Government Advocate Assam for respondent number 4 and 5. Full stop. Agreed by inadequate amount of compensation assessed by the respondent authorities under the scheme land acquisition through direct purchase by way of negotiated settlement and non-disposal of their of the petitioner's representation by the respondent number representation dated what date? Dated 30/12/2025 by the respondent number 4, who is the chairman of the district level land purchase committee. The petitioner has approached this court by the instant petition. Post of issue notice returnable on file. As Ms. Das, Mr. Aforesaid and Ms. Verma, Chidi will respond in extra copies to all.
Fourth.
Okay. The learned counsel paying for the official respondents have submitted that have raised the point of maintainability of the rate petition. Keeping the point of maintainability open to be open to be decided at an appropriate stage. Let notice be issued. The notice is made returnable on such.
14 September, 1409. Item 26.
May it please your lordship. My lord, petitioner is, my lord, providing, my lord, education to charitable trust, my lord, providing education to, my lord, differently able children, your lordship, and running eye hospital, your lordship. So for that purpose, my lord, income tax department has issued certificate under section 12 capital A, whereby, my lord, I have been made entitled for payment of income tax under section 11 of the Income Tax Act. Certificate, my lord, will find at page 36, my lord. This is a certificate issued by the Income Tax Department, my lord. Accordingly, my lord, earlier also, now also, my lord, only in respect of 2 assessment year, that you'll also will find at page 37, next page, my lord, 17-18. We are regularly filing by the nil income tax return. And along with this, my lord, we are attaching, my lord, our audit report. That, my lord, will find at page 39, my lord.
So basically, your exemption, you require what? You require what?
I required, my lord, along with my return, I should also attach, my lord, my audit report as per their impugned notice, my lord. Although we have attached it, but because of the reason that we don't know, my lord, so authority has given us demand notice that, my lord, will find at page 69.
Now you filed a rectification
I have
application
filed, my
also.
lord, page 71. And as per their own circular also, my lord, they are not, they are thereafter also, my lord, they are wishing demand, page 74, my lord.
Page 70?
4 is the, after rectification, page 74. This
Your rectification request has been
filed, my lord, page 70.
accepted.
Accepted, my lord. Receipt is there.
An acknowledgement number has been generated.
Generated, page 73.
Page 73. Now that has not been decided.
Not decided, and they are raising demand, my lord. And as per their own circular, my lord, notification, page 80. Para 3, my lord, onwards. May I read your lordship?
It is for which year?
My lord, it is 1780.
1718.
Here we covered under, my lord, subclause 1, para 4.
Just a minute. No, that, what is the period as per para 4(1)?
My lord. Para 4(1)
In
16
filing.
Assessment year is, my lord, 16, 17 and 17,
In
18.
all such cases where the audit report for the previous year has been obtained,
My lord.
this is first condition, before filing of return of income
That we have done.
and has been furnished subsequent to the filing of the return, but before the date specified under section 139
My
of the Act is condoned.
My lord.
What is that date?
My lord, that
Under
is not
section 139.
139. Otherwise, in page 69, if you
No, no, tell me
My
this
lord,
one
my lord,
first.
my-
Yes, what is the date, Mr. Chetty?
What should, we have to take instructions, man.
Huh?
Because the allegation is, my lord, they have not filed the audit report, my lord, along with the return.
Ah, that is one way. That is not filed electronically. That is the case.
Lordship,
I think
my lord,
you issued a notice
my lord.
because they did not file the audit return electronically.
Lordship,
That is the only case.
lordship,
According to them, they have the audit reports with them.
my lord.
prior to filing of my return.
How can you say that?
Date is there, my lord. Audit report, my lord.
No, that can be prepared also with backdate. That is not the issue.
Audit, because it is I don't think, my lord.
This is not computer generated.
Audit report is not there.
Ah,
But my lord, generally, my lord.
you say that it has been done. But any other evidence that
Because, my lord, in the demand notice, if your lordship will see, they themselves saying that you file rectification application, page 69.
page
69, my lord.
now, when did you file the audit report?
It was
Manually,
filed
manually.
Manually, my lord, given way back when the
Where is that?
audit, my lord, it was given, my lord, no evidence.
It was supposed to be uploaded electronically.
Electronic.
Let us assume it was not done or some technical glitches,
My
right? When did you receive the first notice?
first notice was, it was way back, my lord, on 21/8/2018.
Where is that?
Page 38, my lord.
38.
Annex 3.
38. Communication reference number. So how did you respond?
My lord,
Covering
honestly, my lord, there is no
with covering letter.
My lord.
Look, I failed to e-file.
My-
This communication is 21st August 2018, meaning thereby 8 years back. So on receipt of this notice,
My-
how did you respond that, look, I am giving this physical copy of the audit report?
That is true, my lord.
Where is that?
I have tried to find out, my lord. Open instruction. This is practically, my lord. According to them, it was attached with that portal. And
But that is why I am asking you, show us something
my income tax.
to come within the purview of this notification.
My lord, may I say something, my lord? If my lord audit report is with me, otherwise I am entitled for exemption, your lordship, and I am filing nil return, my lord. There is, my lord, why I will not submit, my lord, that audit
Mr.
report, and that
Goel,
will- my lord.
it is always a case. माथा में है, खाता में नहीं है.
My lord.
Where is your khata?
Khata, my lord.
Ah.
That khata I can show, my lord, page 71 on.
You have realized when?
When this notice was received, my lord, page 69.
Page 69. But 38 you received 8 years back.
My lord, I am told, my lord.
And this exemption is by the circular up to this thing is called known.
my lord,
By this circular,
my lord,
page 80,
my lord.
but before the date,
It was
specified under section 139
my lord,
is condoned, right?
my lord.
Now, this is
Issued on 3rd of January.
this is in
2020.
exercise of statutory power, right? Now, which page?
Page 69, my lord. Kindly see.
69.
It was 22/11/2024, my lord.
So, you were in deep slumber. You responded only after this.
Before that also, according to them, they responded, but it was not on
No,
record.
show us something. That is why I'm asking.
Thereafter, my lord, as per this,
Because nowadays we find that if we
my
don't
lord, my lord, as per,
ask piercing question, nothing comes from the council
my lord, as per this,
most of the time.
my lord, as
And
per
it is for, I am trying to find out something.
True.
Otherwise, it is against you.
my lord. No, otherwise also, my lord, page 69, here they are saying that you file rectification application, para 2, my lord.
69.
My lord. In this regard, when the demand was given, my lord, you are hereby requested to pay the outstanding demand or file rectification if the demand may be reduced through such rectification,
Now tell me, when did you file?
my lord. And demand rectification application was acknowledged on 23rd August 2020.
25. Now, Mr. Setia,
Lordship, all these factual details are there, my lord. I have to take instructions.
well, we can dispose of it. The rectification application is pending.
My lord.
Let him take a call.
Lordship.
It is valid. Take your instruction. Day after
Lordship.
tomorrow, we'll dispose of. If the if the rectification is pending,
Lordship.
they have to pass an order,
My lord. That's
region order,
Lordship.
all the factors, whether within limitation, and if it is limitation is done, then on merits, a speaking order, that is the mandate.
Lord.
Why should we continue with the parallel proceeding?
Lordship, short dates maybe on Friday, Lordship, 14th.
Third, Mr. A. Goel, learned counsel for the petitioner, and Mr. S. Setia, learned senior standing counsel.
Lordship.
Income tax department for the respond number
My lord, I am for 227, my lord.
227. And Miss, please, your good name. P. Boyle and Central Government Council for the respond number 1. Mr. Setia has sought for listing of the case after a week to obtain instruction as regards the status of the rectification application, which was filed by the petitioner and registered as rectification, registered under rectification acknowledgement number, page 73, dated
23/8/2000.
This short for Mr. Setia is the case on after 1 week.
Lordship.
19th August, 1908.
Find out if it is pending, we can direct.
My lord.
Item number 29, my lord. It is same, only the documents is different, my lord.
29.
29. Registration certificate in place of audit report. And assessment is
Registration?
that registration certificate granted by Income Tax Department, one. Page 37, one. In fact, it was issued by them only, one.
37.
37.
Let us see.
12A1.
Then you file any rectification?
Yes, ma'am. Same.
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 Okay, page 74, belag the numbers.
Date is also so.
Number is different.
Number is 1890.
No. Rectification, registration number is different.
Page 74.
74.
Mal.
Is it different or not?
Different mal.
Different. Page 70.
I'm appearing in item number 29.
Okay, madam, your good name?
You borrow.
You will.
You borrow.
You will correspond number 1.
Deep law.
Named it.
1908. Item 27.
My lord, this is also direct purchase. Only difference is that, my lord, in this case, I have come before your lordship for remeasurement of the area. Subsequently, it is known that they have acquired more land of the what land is shown in the record, my lord. Because I have stated in page 8, my lord, clearly. Page 8, para 6, my lord.
Page 8, para 6. Heard Mr. A.Y. Chaudhary, Joint Counsel for the petition. Miss M. Das, Standing Counsel, Public Works Department for the respondent number 1. Three, 6, N. Bordoloi, Revenue Department. 2, M. Bormon. 4 and 5. Also, the case of the petitioner is that he is an owner. He is the owner of a plot of land of a commercial plot of land.
Yes.
Measuring 6 khatas, 8 shotaks, covered by dag number 925. How many pattas?
2 patta.
Paragraph 12.
My lord,
1 dag number under 3 patta.
2 patta, my lord.
Where is dag number?
Just in-
Only 1 dag number, 3 pattas. Paragraph 3 also.
Yes, my lord.
1 dag number under 3 patta.
Yes, my lord.
How to describe it?
There is annexure 1, my lord, that is given.
A parcel of land belonging to a petition came to be acquired under the that what is the name? Under the scheme. Key now, see. What is your name, madam? Land acquisition through direct purchase by way of negotiated installment. Settlement. Full stop. According to the petitioner, the petition has been paid compensation amount for an area of land measuring 2 khatas and 10 shataks. Full stop. It is a case of the petitioner that in area of land measuring 4 khatas and 12 shataks had also been acquired in the process without making any compensation to the petitioner. Full stop. The petitioner submitted a representation before the respondent number. Where you have filed Special Secretary to the Government of Assam.
My lord, that was at My lord, it was informed that some.
Before the
permitted-
respondent number 4 seeking re-measurement stroke variation, re-verification about the exact area of land, comma, belonging to the petitioner, comma, which had been acquired in the process. Post of as no response has been received from the respondent number 4, comma, the petition has opposed this court by the instant repetition. Seeking inter alia direction to the respondent authorities to conduct re-measurement stroke re-verification of the acquired land of the area of land acquired from the parcel of land belonging to the petitioner. Issue notice returnable on so and so, as so and so appear accepted. No formal notice, extra copies, 2 or
14th September. Item 28.
Madam, you're left to the allotment of the shop rooms.
Allotment
of the shop rooms, you know. Under the government.
Allotment of shop
Shop rooms.
under Gaon Panchayat. Okay.
What happened, Your Lordship, there, regarding the allotment, Your Lordship, there are series of litigation, Your Lordship. Ultimately, this honorable court division bench directed to allotment to be done through tender process.
Tender.
The petitioner has no grievance regarding this.
Huh?
Petitioner has no grievance regarding this, Your Lordship. But what happened, Your Lordship, the process which has been initiated, that has been challenged here. As per division bench directed the rules, Assam Panchayat rules 2000.
Where is the judgment?
Judgment, Your Lordship. Page 82 onwards. Page 82, may kindly present.
Page 82.
Paragraph 13, last paragraph. Thus, it is clear that the sale settlement of market which would cover the shopping question has to be done strictly in accordance with the mandatory requirements of Rule 47 of Assam Panchayat Rules 2000.
Just a minute. Yes.
Rule 47(5) says, Your Lordship, and the tender shall be opened, processed, and settled by the committee as provided in subsection 1I of section 22, and subsection 1A of section 52, and subsection A of 81. Basically, Your Lordship, a standing committee has to be formed from Your Lordship.
Standing committee is always there.
Yes, Your Lordship. But here what happened, Your Lordship, kindly tell the last and actual.
That matter reached Supreme Court.
Yes, Your Lordship.
Yes.
The tender has been opened by the representative.
Where is the tender?
Tender notice, Your Lordship.
NIT. NIT.
51, 57.
50?
51.
51. That is 51. 51, that is of 2019.
Yes, Your Lordship. That's the issue.
No. What is the division bench judgment?
Division.
When the division bench judgment,
Division bench judgment.
date of
start
the
from
judgment,
Page 75.
38, 2023. Paragraph 15. Read.
Admittedly, the mandatory process stipulated in the above mentioned provision of the Act and the rules was not followed in the present case, and hence the leasing of the shop in question to the appellant petitioner was totally illegal. That apart, it is admitted that the lease deeds heavily relied upon the appellant's counsel were issued by the president of the Gau Panchayat in his own individual capacity, and they do not have any sanctity in the eyes of that.
So, this judgment was rendered in 2023.
That's a-
And you are referring to a tender notice of 2019, which has been held to be illegal. Right? Anything done prior to 38, 2023 was held to be illegal.
illegal.
Now, you have taken me to page 51, which was the tender notice of 2019.
Right.
Why you have taken me there?
Because your lordship, the whole story involves
No, that is all held to be illegal.
illegal.
Gone.
Gone.
Where is the new NIT?
That process continues.
Cannot be.
Regarding this, your lordship, there are writ petition pending, your lord. 917, WPC 917, 2026. I have annexed the order.
Because division bench says thereafter that has been affirmed by Supreme Court. Now, it's paragraph 15. Everything is held to be illegal,
Illegal.
right? Meaning thereby there has to be a fresh process.
Process.
Where is the new NIT?
Thereafter, no new NIT has been issued, your lordship.
Then-
on the basis of that NIT, your lordship, allotment was done. That's what we are challenging.
No, if that is already under the subject matter of different writ proceedings. Now, why you have come here?
Because we have put in this writ petition, we are challenging the process through which the NIT has been.
Huh?
conducted.
Process?
Process challenge, process through which the bid has been opened.
Then for
Lordship, kindly peruse the last annex, paragraph, page 130.
page
130, annexure 17. The meeting has been presided over by the, may I read, your lordship?
130.
130.
But Mr. Mira, before reading and wasting time, once again we see the date of the division bench judgment, 38, 2023. And this is of prior to that. All these are illegal. Why you are showing me this?
No. Well,
This is of 28/3/2023.
on the basis of that resolution, your lordship, allotment has been done. Allotment has been given to the private respondent. Lordship, regarding the allotment, there are other writ petition pending, your lordship. May I peruse that writ petition may be tagged with the other.
You have not prepared any other writ petition earlier.
Oh.
After the division bench judgment,
Prepare,
Huh?
we have
Preferred. with seeking what relief?
the allotment has been given to the parties who are not entitled to.
Where is that annexer?
Your lordship. That issuance of notice, I have not annexed, your lordship, but the respondent has filed in my affidavit in opposition in the.
No, if you have after this, after the division bench judgment, right? You want to say this, I have seen your prayer now. You are seeking quashing of the proceeding of Gram Panchayat dated 28/3/2023.
Yes.
Right, first prayer. Second prayer is also related to that. Third prayer is regarding something refund and to undertake a fresh settlement process. Now, after your writ petition, which you have filed after the division bench judgment and Supreme Court judgment, what you have challenged?
We have challenged, Your Lordship, that on the basis of that.
What you have challenged?
Yeah, Your Lordship, we are.
Tell me your number, we will list it along with that.
Yes,
writ
yes,
petition.
205 of 2026.
Heard Mr. K. Miral and counsel for the petitioner. Yes, yes, Madam Boda, what do you want to say?
Lordship, similar matters are pending.
No, similar matters, they have also filed a petition already.
Lordship.
What they have filed?
Lordship,
You take instruction, 4 weeks.
no. Because
Okay.
similar matters are pending on 20.
Let the court examine then, petitioner. Miss Ann Boda. Okay. Pending counsel, PNR. 1, 3, 5, 6. Miss M. Borman. 2. Close. Mr. Meera has submitted that the petitioners have filed another petition from a WBC number
205 of 2026.
205 of 2026. Post of release this petition along with WBC number so and so on Friday.
On that writ petition has been fixed on 28.
20.
20.
Okay, okay. Mr. Meera has submitted that the WBC number so and so is ordered to be listed on 20/08/2026. So list this case also on 20/08/2026.
Item 30.
His Lordship. Petitioner's current bank account that frozen by the bank.
Yeah, I got Mr. Current Bank. Mr.
Jayuddin.
Yeuddin. You are for?
I'm for union, respondent 2 and 3.
Okay. You are Central Government Council?
Yes, ma'am.
Okay, Mr. I. Botakur, I am Central Government Council for respondent number 2 and 3. It is a case of the petition that the petitioner is maintaining, has been maintaining a current bank account number so and so at Bahrampur branch, Nagaon of the respondent Punjab National Bank Limited. Respondent number 4. So, the petitioner has proposed this court by the instant requisition stating that without any prior notice and without disclosing any region, the said bank current bank on the petitioner has been kept blocked by the respondent number 4, partly on the instruction of the respondent number 3. Since when? So, issue notice we can also is 2 and 3. Steps upon respondent number 1 and 4 by speed post. Our last one you do. Huh?
1409.
Last
1
one you do.
14 September.
Suspicious transaction.
Apply. Item 32.
Here, my lord, petitioner is the charitable trust, your lordship, and petitioner was granted my lord registration. Page, my lord, 26. My lord, it was valid for my lord 25/26. And
Page 20?
26 is registration, my lord.
26, yes.
And assessment years, your lordship will see serial number 8.
Yes.
My lord. My lord, as per my lord, section 80G, my lord, before expiry of this registration certificate, my lord, prior to 6 months, I have to apply for renewal, your lordship. That I have not done. There was delay, and application was given, my lord, for condonation of delay. That your lordship will find at page 28. Well, this is the and condonation application, page 40, my lord, 40.
40.
Condonation application, my lord. But no order till today, my lord. They have passed. In fact, my lord, in the month of August, your lordship, on 7th August, not 7th August, 7th July, my lord, they have issued one note, circular, page 43, my lord. And my lord, serial number 4.
Examine.
Further, where an application in Form 10AB filed electronically between so and so has been rejected as on date of issue of circular solely on the ground that it
No,
was
you have to read.
serial number 4, my lord.
You have to read 3.
3, my lord. The matter has been examined by board in order to mitigate genuine hardship to such funds and institution. The Central Board of Direct Taxes, in exercise of powers conferred under section so and so of income tax read with so and so, hereby condones the delay in filing Form 10AB, where the prescribed application in Form 10AB has been furnished electronically between 1/10/2025 to 31st/3/2026.
When did you file?
Well, 18/3 to 2026.
Then? 18/3.
Well,
So within that time.
within that.
Huh.
But my lord, since my
Read.
further, my lord, the jurisdictional principal commissioner of income tax or commissioner of income tax are authorized to dispose of such application on merits and pass an order on or before 31st/12/2026. Thereafter, my lord, I will come, my lord. Further, where an application in form so and so filed electronically between so and so has been rejected as on date of issuance of circular solely on the ground that it was furnished beyond the prescribed time limit of 39/2025. I fall under this, my lord. The delay shall be deemed to have been condoned in such cases. The jurisdictional principal commissioner of income tax or commissioner of income tax are authorized to dispose
No,
of
further, when an application in Form 10AB filed electronically between 1/10/2025 to 31/3/2026, right?
No.
Condition is that has been rejected. Where is your rejection?
I'm just.
Where is your
There is
rejection?
nothing, my.
Then why you are going to para 4?
My. This is the understanding, wrong understanding. Para
No, where is your specific order?
My, para 3 will.
Any application has to be disposed of by an order.
My.
Why you are referring to para 4?
Para 3. I'm sorry. Para 3.
Don't try.
Para 3. My lord, wrong understanding, my lord.
Not wrong understanding. I will not
So far as
presume. I will
rejection-
not presume that since you have not annexed any order of rejection, where is your statement that your application has been rejected?
Application has been.
Application for condonation has been rejected.
But I am not saying it is rejected.
So then why going to
That-
para 4 repeatedly and showing me and allow? You have let the court to read paragraph 4.
This
And
I'm sorry.
it is cannot be presumed that Mr. Goel does not understand the English language.
I'm sorry, my lord. Rejection part I.
So this is premature.
My lord, for passing order, my lord. Because
It is passing order.
My lord.
Firstly, you are at default. You were at default. Then you made the application on 18/3/2026. Now they have extended the period up to 31/3/2026. Right? Now the principal commissioner will take that application on board and decide on merit and pass an order on or before 31/12/2026. Now that is the mandate by in exercise of power right? They have issued the circular. Is it not?
My-
Let us see first paragraph now.
Section 80G of Income Tax
Huh.
Act provides.
So they have exercised the statutory power.
My-
Now power is, by that power, they said they will decide on 31/12/2026. Principal Commissioner. Now, on that basis, now whether I should direct this court should direct that no, Mr. Goel is very important. So please, within 7 days, they have issued this in exercise of statutory power. Should I exercise that power?
But here the problem is that. my-
Problem associated with your default. You made the default. Is it not?
True, my-
Now, where is your power to right to ask for something? Renewal was supposed to be filed.
Prior to expiry of 6.
Hardship, we don't know. You did not file. Time expired. Somehow, similar situations occurred in other cases also. Taking into purview all those situations, they, in exercise of their statutory power, right?
My-
Under section 1192B and section 536 of 2025 Income Tax Act, they have relaxed the period.
But
And they have taken the jury that will decide on or before 31/12/2026.
which application? It says the delay has already been condoned by the, but you also will see so and so hereby condones the delay in filing. Delay has already been condoned.
No. The matter has been examined by the board in order to mitigate the genuine hardship to pass to such funds and institution. Central Board of Direct Taxes in exercise powers conferred under section so and so hereby condones the delay in filing Form AB,
That this is my, there is a delay in filing.
where the prescribed application in Form 10B has been filed. When did you file it?
18.3, my lord.
When did you file?
18/3/2026.
So thereby delay is condoned.
Condoned.
Now, Principal Commissioner will pass an order about renewal. I think it requires renewal.
My-
That he will pass.
Yes, Lordship. The circular, my lord, which was issued that condoned the delay. Now, my lord, the consequential order that has to be
That
passed by the
order
commissioner.
renewal will
Lordship.
be passed.
Lordship.
Why you are, Mr.
In fact,
Goel,
we
you are
have
trying here and there, taking me here and there
My lord.
to try to interpret this when the logic is clearly
In fact, my lord, this is premature, my lord.
explicit. Why you are trying to find a different meaning from paragraph 3?
Para at 11 and 12, my lord, we have stated, my lord, we approach the authority.
No, he has the discretion to pass the order up to 31/12/2026.
But the
And statutorily he has been given. Now, in such a case, whether 226 is to be passed, order is to be passed, power of judicial review and the power of read in the nature of mandamus. No, Mr. Goel is very important for the nation. So please take his.
Not on that. my
No,
lord.
why then you are interpreting it?
But the charitable trust, my lord, they are.
Charitable. You are not the only one, Mr. Goel. This is taking into account that in order to mitigate genuine hardship in such funds and institutions, you are not the only one. Is it? Shall I ask for a number? Or if you are entitled for priority, then we'll examine. We'll issue
Priority, my lord,
notice.
because I am unable to receive donations, my lord, because I am
It
unable
is-
to give receipt also.
And who was at default first?
I am.
Huh?
Delayed is on my part.
Who was at default?
Petitioner.
And how many are such funds? Can you give the figure? 10,000, 1 lakh, how many in India? Huh?
That figure I don't.
Give us, make an RTI. Then you are the only one,
I'm not
which is
saying-
very important for the nation. We'll issue mandamus then. Is it not? Heard, Mr. Soins, A. Goel. It is premature.
Lordship, because my lord, the time is
Absolutely
still there
premature.
up to my lord 31/12/26.
In that case, my lord, the lordship may allow to withdraw it and liberty may be given, my lord, if my lord, some cause of action arose, my lord.
Absolutely. You are not the only one. Or otherwise you can issue notice.
Apparently, my lord, it is premature.
Notice me, my lord, I think if the lordship, otherwise I am withdrawing my lord.
Otherwise it is very premature. We'll keep the issue of premature nature with petition open. Next we can close.
Continuation.
Heard, Mr. A. Goel, learned counsel for the petitioners. Union of India,
Yes, lordship, I am.
Mr. J. K. Goswami, learned Central Government Council for the respondent number 1. Mr. S. Setia,
And for 228, lordship.
228. Shall we dismiss or withdraw?
I am withdrawing, my lord. Only
Mr.
liberty may be given, my lord.
Goel, learned counsel for the petition. Has submitted that in view of the circular dated circular number 06/2026 dated
7/7/2000.
7/7/2026. The petitioner wants to withdraw the writ petition with liberty to approach again in the event of any fresh cause of action.
And liberty may be given to approach the authority, my lord. To authority also.
No, that is you are at liberty. In view of the above submission, well, and transfer for the petitioner, the petition is dismissed on withdrawal with the liberty as sought for.
I am on that.
Supplementary list, item 51.
Yes, no?
May I please, your lordship?
Which one is this? That one.
Yes, ma'am.
Okay, Mr. Will issue notice, short notice next week. Otherwise, it is not possible to dispose it of on a motion day.
Ma'am.
You have filed your affidavit.
Pleadings complete, my lord. Affidavit reply both files.
20?
Ma'am, any day convenient.
20?
Any day convenient.
Heard Mr. S. Das, learning counsel for the petitioner. A.K. Chaudhary, CGC 1, B. Gugoi, standing counsel, Finance and Taxation Department for the respondent number 2 and 3. Posted. Let notice be issued having regard to the issue involved in this writ petition and as agreed to by the learned counsel for the parties on the ground that the exchange of submission that exchange of pleading is complete, the notice is made returnable on 20/08/2026. And then never will be made for consideration of the writ petition on the next date of this.
But it will be listed at motions, madam. Listed under motions.
On a hearing date, notice issued meaning but have a admission.
Admission.
Item 52.
Hearing no jano, 20 তারিখ
Same, my lord, let it be on 20th, my lord. Yeah, regarding cancellation of registration, I have filed the affidavit placing all the, my lord, provisions.
Okay.
Regarding re-registration, is there in the affidavit now?
That is an issue, otherwise
Yes,
we are facing with all,
yes, ma'am.
okay. It is all encompassing or,
It will cover, my lord.
Okay.
In a new line, my lord, one order can be passed in that manner that they will go for re-registration.
any authority of the Supreme Court? No.
In that regard, there is embargo now. So,
Any authority from other
no,
other
there
high
is the
court?
option given in the statute, my lord. They can opt for that.
Any judgment of other high
Yes,
court?
my lord, yes. No, as on that, no. As on that, no.
Okay. M. Das, petitioner. And Miss R. Dotto
Union.
on behalf of SK Meti. Oh, sorry, B. Google Land Standing Council Finance and Taxation Department, Government of Assam, for the responding number.
My lord, yes.
224.
224.
R. Dotto, Learned Council on behalf of. Okay. Who is for one? Okay, 1 to 4. Oh, nowadays Union of India. Okay, amended cost title. Mr. Gogoi, you point out whenever Union of India is not made part.
My lord, my lord.
Because now it is mandatory.
Mandatory.
R. Dotto on behalf of Mr. SK Medi, Learned Settlement Council. For the respondent number 5. Same likhe dibo. Agor to nisna. 20/08/2025. Notice issued. Right? Made returnable. If you want to file any reply, you have filed affidavit.
Yeah, you file that.
If you want to file any reply, file reply.
Item 53.
Madam, it got listed at last tomorrow
Tomorrow, I mean,
because we will be disposing it of. Is it not?
Lordship, day after tomorrow.
Motion day to dispose of, madam.
Then Thursday, my lord.
Thursday. Mr.
Lordship.
It appears this one. What is the issue?
Issue section 18 to notice was issued, my lord, over a patta land of the petition.
Something like that.
It's a so-called notice, Lord. Page 27.
Okay.
Page
27. That is under challenge, the impugned order. 10/7/2026. Third paragraph. You are therefore directed to show cause and file representations along with supporting documents within 15 days from the date of issuance of this notice as to why you should not be evicted from the said land. In the event you file such so
where is your DAG number, pata number?
Tag number.
Government land number, government DAG number.
Government level tag number 9. But it was a settlement, land was settled with the petitioner, with the fathers of the petitioner. Miller settlement order is at page 16, Miller.
They can very well place all these things before the authority concerned, Lordship, who has issued the notice.
But no.
It's only a so cause notice. This is not an
We have
eviction notice.
filed representation, Miller, but till now no order was passed, but threat of eviction was.
Mr. Sharma, otherwise paragraph 2.
Lordship. In page 27, Lordship. And whereas such unauthorized and illegal occupation of government khas land
Enter
is
into possession of government khas land.
Yes.
Then he said, when, how 18(2) will come in? Khas land.
That is why, Lordship, this is only a I am only on that, it's only a so cause notice. They have been directed to place the documents. In the event you file such so cause representations, the same shall be heard and decided in accordance with law. Thereafter, the reply is submitted by them, Lordship. Now, no action has yet been initiated. Accordingly, they are apprehending.
Now come to page 23. Read the remark.
উপায়ুক্ত মহোদয়ৰ ইমান তাৰিখৰ ইমান হুকুম মৰ্মে দাগৰ 19 লেচা মাটি চিলিং আবণ্টন মতে এই পট্টাৰ দাগত ভুক্ত কৰি মেডি পট্টা কৰা হ'ল. Yes, Lord, I am not denying. I am not at all.
No, we also know after reply, the standard order will come.
Then I leave it to your Lordship.
Is it not?
Then I leave it.
See the notice. How,
I am-
how the dark number has been mentioned?
In handwritten, Lordship, down below.
Nine.
Is it
part.
a way?
Doc number 9 part.
At
Part
least this case, I'm not saying, come to page 20.
Lordship.
Right. We don't know genuineness of this, but page 20 something is there. Then thereafter the Jamabandi.
No,
Prior to
I
that-
am not denying, Lordship. I am placing my submissions on my point of view, Lordship.
16. 16,
As
if you
because
can
I-
read.
Yes, Lordship.
This cannot be ignored while issuing notice also. These kind of orders, just you will pick up somebody, write the name in pencil, issue a standard notice. Is this not some high-handed action?
No, at this stage, I am unable to ask because whether these documents are before them or not, that is why most probably on the basis of some complaint, they have issued this notice. Maybe, Lordship. From my point of view, I am submitting as because it's in the motion.
Pardon me,
stage,
that's right. I will stay then. Learned counsel for the petitioners. And Bordeloi, revenue, 1,
2, 3, and 4.
2, 3. So the petitioner has approached this court. Agreed by. A notice. Agreed by. Issuance of notice. But madam, you have replied to it.
Yes,
No, but
reply has
no
also
action was
been.
Given, Milord, till
Huh?
now. No action was given.
Then you have replied, you have not come at the
That's
first hand.
There is a,
You have already submitted to the jurisdiction.
yes, Milord, but there is a threat of eviction, Milord. Already there is a threat of eviction. Milord.
Then
We
we
are-
will
we are-
dispose of this since the petitioner has filed a reply. Then we'll dispose of with an observation on Thursday.
That's because they have also mentioned in the writ petition, Lordship, there is a threatening to proceed with eviction. That may be stayed till disposal of the.
Right.
Yes, Lordship.
We'll
I-
we'll allow the person to pass a speaking order,
Lordship.
but we'll observe these are the documents placed before the court. If you have submitted, they have submitted the documents, and he has to take
Lordship,
give due consideration to
Yes,
those
yes.
documents and pass a speaking order.
Yes, Lordship. Otherwise, Lordship, one day in this type of notices might come to me.
Yes,
also,
yes.
Lordship.
That is why
I am with them, Lordship. But
I am surprised. Thursday.
Lordship,
13th August,
Please.
1308. Timing method, item 15.
Yes.
Unless this matter pertains to levy of charges of around 3 crores on my bank account. That is a working capital account, my lords.
On what? Who? Bank.
Yes.
Then?
Leonard Fund is appearing, central bank.
Copy not received. Copy has not been.
What is the? These are. Is it a forum to agitate?
My lords. Because what had happened, my lords, we have also gone to the ombudsman. Ombudsman, without hearing, had rejected that application outrightly. I don't know why.
These are issues. If it is there is deficiency of service.
No, my lords, there is no deficiency in service. What they have done, my lords, if you honor, kindly see their email. Just see their email, ma'am. Page 69. This is a working capital account, my lords.
No, these are banking transactions.
My lords. My lords will see the tabulation, my lords. 47 crores is the limit amount. If 2% is charged, it cannot be 1 crore 67.
No, where, which page?
Page 69, my lords.
What does it mean? What kind of document is this?
This is an email received by the bank, my lords. They have already debited around 3 crores of sum from my
No,
account.
please make me understand.
My lords, my lords. What has happened, my lords? We are having a loan from Central Bank of India. There are 3 loan accounts. All are CC accounts. One it is in Jorhat, one is in Gauhati, one is Banaras. Now, my lords, what had happened? Different bank accounts have different CC limits. We said that we do not want your CC. So ultimately, down the line, we started repaying, in the sense this is a working capital. As business money comes up, the flow gets into it. It's not a term loan, my lords. Eventually, what happened, my lords, in the year 2025, we said we do not require your services. So eventually, the amount was debit. There was no credit debit balance. Everything was credit. My lords, may kindly come to bank statement, page 70.
It's a contractual dispute.
Right, that is why I'm thinking over some contract,
My lords,
loan account.
my lords,
Why we should, if they have done something wrong,
my lords.
would not it come under deficiency of service?
No, my lords, because
These are factual, they're questions of fact. A number of questions of fact would fall for determination, right? What does the ombudsman held?
Ombudsman, my lords, may come up to directly to page number 145.
He says there is no deficiency of service.
My lords,
You would say there is deficiency of service.
my lords,
That is what?
my lords, as far as the ombudsman scheme is concerned, my lords, may I just place on record?
No, after ombudsman, if the number of questions of fact would fall for determination, what are the forums available? Tell me first.
Against,
Tell me first.
I can go to the civil court, my lords.
One.
Yes, my lords.
Second,
Second, the consumer. The consumer, because this is the commercial transaction, my lords. Consumer, I cannot go.
they should come.
No, because it is a commercial transaction.
Shall I place?
My lords may be correct, my lords, but to my understanding,
Second forum. Then third, this could be when 2 forums are available. What is said normally?
forum shopping.
No,
Part time.
you have to adjust the remedy. Then you come.
My lords, as far as the ombudsman.
You directly run at the drop of a hat, saying deficiency in service. Come to the bank. Oh, bank, let us go. Get an order. First, you satisfy me on the basis of authorities that this is the only forum and none else. 226 is the only remedy for you. Then I'll issue notice. You take loan, they say this is not our policy. You cry foul, come to the High Court. Ombudsman find no deficiency in service. Why will decide all these issues?
My lords, in that.
What kind of fundamental right? This is a contractual right.
My lords. But now, as a-
Contractual rights of in a non-statutory contract.
Yes.
Maybe bank is an entity under Article 12, but this contract is out of your volition. Somebody breached. What is the forum?
I can go to the commercial courts.
Satisfy me.
My lords, may this
Day after
matter be
tomorrow.
taken on Friday, my lords?
You have to satisfy.
My lords.
Otherwise, this kind of petition will clog down the system.
I'll try, my lords, on Friday.
This will clog the system. A.K. Sahewala, petitioner, and Mr. M. Sharma, Learned Counsel for the respondent bank. Mr. Sahewala has sought time till Wednesday to
Friday.
Friday, to make submission that the writ petition under Article 226 is the only remedy in respect of the grievances of the petition. Am I clear?
In the meantime, you'll also copy.
1408.
A copy.
Production list. Item 1, Musak Agro LLP versus State of Assam.
What is this?
My lord, there's a small prayer. Can it be taken up tomorrow morning at 10:30? Mr. Borpuzar is on legs at the moment.
What is the impugned order?
Your lordship, what has happened?
No, no, impugned first.
Three
Huh?
documents, page 34 may be seen, your lordship. Am I with your lordship, 34? In exercise of power conferred on me under section 3.
This is 3-1, okay.
3-1.
Huh.
Then I preferred an appeal. That is at page 36.
Huh.
That was 30 days, your lordship. The date I've given 29/5/26, they have received on 3/6/26, 30 days. Appeal is pending, your lordship. Now, I've given an intimation to DC also, page 43, and in page 44 now, the notice has been issued under section 4 for possession.
Possession.
Yes, your lordship. Section 4 is possession.
Did they pass an interim order somewhere? Because Borpuzar was there. I disposed of.
Can it be tomorrow?
Tomorrow then, tomorrow. We get the order.
Fine.
Because appeal, I directed them to appeal, pass an appeal, state government to pass an order. Right, till then, no.
Yes.
I have forgotten the order.
Fine.
Mr. Borpuzar was there.
Yes, yes.
That airport
Yes, yes.
requisition of lands near the airport.
Yeah.
Tomorrow.
Requisition for the purpose of acquisition. Now,
Yes,
that's the.
requisition for the purpose of it.
Nowadays,
Because
D. Senapati for the petitioner, A. Authorised revenue 1,
2, 3.
and Mr.
4, 5, 6.
and 2, 3,
4, 5, 6.
4, 5, 6. Raise the case tomorrow. How many productions?
Item 2, Vivekananda Academy Senior Secondary School versus State of Assam.
May I please, Your Lordship?
What is the case about?
Lordship, before coming to the impugned order, my lord, may I narrate the background fact?
No, there is no time for narration.
Before he starts, my lord, I am applying for GMDA. GMDA has not been made party. Lordship, he is challenging an order which is a statutory appeal under section 73. Order page, impugned order is in page number 71. So there is a
Appeal?
provision, page 71, my lord. The provision of section 73 of the GMDA Act. There is provision for appeal. And GMD has not been made party. And this is a resident.
This order has been issued by the Chief Executive Officer GMDA, who has been made party as respondent number 2, my lord.
GMDA is not a party.
And the urban state has been represented by the Secretary, Commissioner and Secretary, my lord, Department of Housing.
This body, GMDA, there is a statute, 1985.
My lord, I understand.
Right? And you know law.
Yes.
So GMDA Chief Executive Officer, he will represent GMDA. Then
And
next one is CEO. He should have made the
my
entire
lord,
party.
I'll do that, my lord.
And
Then-
this is what?
Statutory appeal is section 71.
My lord,
We have been consistently holding that.
may I go that, my lord? At page 71, my lord.
No, why it is today already sealed?
No, my lord.
It is.
It has not been sealed. So
Okay.
they have directed.
Mr. Bora, don't seal today. Tomorrow we'll take up.
Well, let it be day after tomorrow, not tomorrow, my lord.
But don't.
Well, at the same time, if Lordship goes to the pen number 48, my lord, planning permit, he takes down that.
We'll look into it because I have an online
Lordship.
thing just
Lordship,
after 5
Lordship,
minutes.
Lordship.
Otherwise, I don't have any problem. Tomorrow onwards, I can sit up to 6 o'clock. Today, I have a problem. So, tomorrow?
Tomorrow, if Lordship can take
You are not there.
second half, my lord.
Okay. Second half. BM Deka and S Bora. You make the thing required, amended cost factor,
I'll do
if
that.
required.
My lord, till tomorrow, my lord, that may be stayed, my
Sir,
lord.
inform.
Lordship.
I think use your good office.
Lordship, Lordship.
My lord, that
I have
authorization-
asked him to, because I have not, Mr. Bora.
I will inform, my lord. Let it come tomorrow.
Item 3, Bimola Sahu versus Telobasam.
Yes, what is the issue?
Well, eviction matter, my.
Eviction matter tomorrow is going to happen or what?
My lord, kindly see page 62, my lord. One social media post has been, my lord, given on that basis, my lord, eviction is sought to be, my lord, done. Over.
Huh?
Page 62. The petitioner is a, my lord, patadar of a particular land, my lord.
Now, where is the notice?
No notice, my lord, nothing.
You are patadar.
My lord.
How can it be?
My lord, on the basis of the, my lord, pressure of the, my lord, student union, my lord. This is local authority, my lord.
Yes, ma'am.
Kindly protect, my lord. Some status quo order assembly.
When it was?
My lord, it was in Dhokwa Khana, at Dhokwa Khana.
No, when the social media,
My
where
lord,
does notice?
no notice, my lord. Kindly see page.
No notice.
No, nothing. I've stated in para 21 of my petition how the matter goes.
Yes, madam. What is your area of land?
My lord, only 7 lessons.
Where from? Where is land document?
My lord, kindly see, my lord. It is page 35, my lord. 7 lessons was my allotted in the year 2006, my lord. Page 35 on 10/1/2006. But the land was subsequently, my lord, reduced to 2 lessons, my lord. Page 49. Oh. Page 45, you'll also kindly pose.
Okay. Heard Mr. P.J. Soigal, Learning Counsel for the petitioner, Miss Mr. A. Aforesaid, Revenue 1, 2, M. Bormon, 3 to 6. Person. Mr. Soigal has permitted that the petitioner has an apprehension that the petitioner is likely to be apprehended within a day or two from a plot of land measuring.
Earlier, my lord, 7 lessons. Now, my lord, reduced to my lord, 2 lessons, my lord. Page 45.
2 lessa?
Yes.
2 lessa is how much?
Lessons, my lord.
Huh?
Just this area, my lord. It may be, my lord, 20 feet by 20 feet.
This much?
Yes, yes.
This much?
It must.
20 lessons.
Huh?
20 lessons,
1 katha.
But this much area will be, my lord.
144 square feet.
288 square feet.
Yes.
288 square.
Measuring 2 lessas.
2 lessons.
Within bracket 288 square feet.
Yes.
Under Dag number
807,
807,
my lord. Of village whose Gaon, my lord.
village Bhusgaon.
Or it is also called my Bali Gaon, my lord.
Having regard to the materials brought on record, with primacy, appears that the petitioner has been residing in the said plot of land since 1989, that's 1990.
My land is 68, 60.
Huh?
68, 67, my lord.
I have seen page 35. You have taken me to
My-
page 35.
This says, my lord.
Huh.
Yes.
Lays the case again on Friday. The state respondent shall not take any coercive action against the petitioner in respect of the subject lane in question till the next date of list.
1408, 14th August.
Obliged, lords.
Yes, whoever wants to have this.
Item 50, my lord.
Item?
Item 50, my lord. 50, my lord.
Okay,
There is a urgency,
just a minute. What is 34?
My lord, my.
Who is for you? Yes.
34. What happened, my lord? The government rejected my prayer. And you go.
No. Now tell me now what is the case? They have filed the affidavit or not?
A file affidavit, we file reply. Only thing is this, my lord, they taken the plea that my prayer is rejected. That rejection order is to be produced before your lordship.
Okay, to 34 to list code you got next week. Then 35 somebody was
50, my lord.
One by one. Don't be impatient. Mr. Chair, you mentioned-
35.
Actually, my lord, for item 35.
Yes, who is for you? You are for that. Yes, Mr. Counsel.
Yes, my lord,
You are mute.
Am I audible now? Am I
Yes.
audible? Yes, my lord, since they're praying for time for filing affidavits, let it be given. I have no objections. Let it be extended, my lord, because we are enjoying an interim order.
Okay, I can see.
Yes, make your submission.
Lordship, may I
Yeah,
extend
35.
Mr. A. Chakraborty, Learned Counsel for the petition. To virtual mode along with Mr. D. Bhuya, Learned Counsel for the petition. Mr. K. Jain, Learned Counsel on behalf of Mr. S.C. Kyle, Learned Senior Counsel and Special Counsel CGST for the respondent number 1 has sought for and is granted how much time?
3 weeks, lord.
3 weeks time to file a counter to establish the case on so and so.
9
The interim
September.
order passed earlier shall continue till the next date of list.
0909. 9
36.
September. 36.
36.
Item 36.
I need to file my.
Okay. Miss
E. Devi.
E. Devi, petition for the petitioner present. Mr. M. Das, Learned State Council has sought for and is granted 3 weeks time to obtain the necessary instruction and to file the counter affidavit on behalf of the state respondents.
Instruction received only affidavit.
Okay. Release the case on so and so.
11 September. 11
37, what is that?
37.
What is the subject? Instruction received?
No, your lordship.
Not received.
Not received.
Okay. Mr.
Jayuddin.
Jayuddin, petitioner present. Mr. M. Sharma, Learned Counsel for the respondent, Bandhan Bank Limited, has sought for and is granted 2 weeks time, same, to obtain instruction and to file the counter affidavit on behalf of the state respondents. Then 38.
It was 0209. 2nd September. 38.
Lordship, interim may be continued.
Okay. Conchar, nobody is available. Okay. Release the case after 2 weeks. The interim order passed earlier. Due to paucity of time, the case could not be taken up today. Release the case after 2 weeks. The interim order passed earlier shall continue till the next day.
Item 39.
Date to deliver. 39, what is that?
2608.
Count paging, your lordship.
Your lordship, here I have received the instruction. There are only 2 amounts.
Release the case on so and so.
Yes.
Next week.
Yes.
Next week. 14th August.
44.
1408. Item 44. 44.
Okay, pass over then. 45.
Item 45. 46.
46 sometime, my.
Okay.
To file affidavit.
Mr. N. Das, Learned Junior Government Advocate, appearing for the state respondent, has sought for and is granted 3 weeks time.
3 weeks, my.
3 weeks to obtain the necessary instruction and to file the counter affidavit. Release the case accordingly after 3 weeks on a date to release by the office. 47.
Item 47.
47, lordship, I pray,
Interim may be continued till next day.
I pray for listing the matter on Wednesday, your lordship. We have some urgency, your lordship.
Friday.
Friday.
Friday 14th August.
Your Mr.
Our board lordship for restaurant
Your
number 5 and
miss?
6.
Didas.
Didas, as sought for, release the case on Friday. The interim order passed Friday shall continue till the next.
Obliged.
Item number 54. 55.
Your lordship, I'm appearing on behalf of my senior Enbora for the respondent IOCL, your lordship.
The matter relates to land dispute, your lordship, and my senior is presently out of station. He has already submitted his leave of absence. I pray the matter be listed after 20th of August.
Okay, let it pass over then. It will be listed automatically.
Your lordship.
Any other?
There was an
Interim order?
Yes. It may be continued.
Okay, Mr. Your for
Uh,
petitioner?
Petitioner,
Now, your name, please.
A. Rajkar.
A. Rajkar. But a petition is present, Mr.
Because that's for N. Burua.
B. Das, Learned Counsel, on behalf of Mr. N. Burua, Learned Standing Counsel, IOC, for the respondent of 1, 2, and 3 has sought for listing of the case after a week. List the case on so and so. The interim order passed. I shall continue till the next.
2108. Item 4.